Mention it. May I please, Lordship? I beg to mention item number 40.
40.
Lordship, senior counsel is out of station. Kindly adjourn for today.
Rejected.
Lordship, senior youngest counsel already filed leave petition.
Sorry.
Leave petition submitted senior counsel. That,
The petition submitted senior counsel. So why should it be adjourned? It's a 2017 matter, 6-year-old matter, rejected. We'll take a look what it's about. Next item.
Obliged.
May I please, Your Lordship, I beg to mention a listing of the case.
Listing. Please
Listing
give it.
video. Item for admission.
May it please your lordship. Lordship, I'm appearing on behalf of the petitioner. She is not well, completely bedridden. She has prepared a report as per the direction of the court. Kindly allow me to submit it, sir.
Want to submit some report?
Yeah.
Please submit. Yes. What further progress?
Lordship, there was a meeting held on Lordship 22nd of June, Lordship, and then that material which was taken from the Bhava Institute, Lordship, we have tasted few vegetables, Lordship, but all those like 12 marketed we have done, Lordship, but those were found negative. But then later on, Lordship, by the usual process, we took samples and 51 samples, out of which 12, Lordship, have taken tested negative, Lordship. 12. So we have taken
12 out of 50, 12 negative.
51.
Out of 51, 12 negative.
Yes.
What about the balance?
Total 10 number of regular samples were collected, Lordship, till June 2023, which were tested.
No, what we're asking is if 51 samples were collected, 12 were found negative. What about the balance 39?
Lordship, extremely sorry, Lordship. 10 were taken samples of 10 samples were taken, out of which 3 were found to be pesticides positive, Lordship. We have taken action, Lordship, against them. And
What kind of action you have taken?
Lordship, we have
You are for which department?
Lordship, for the health department.
Health department. What kind of action then did the health department take? You are for which department?
I'm food analyst, I'm commissioner of food safety.
You must be the more relevant department. What kind of action you have taken?
10
Please come forward, not from there.
Lordship, 10 regulatory samples were collected, out of which three were found to.
So what we can understand that those testing kits, it's showing negative, but the regular test is showing positive in some cases.
Yes, yes,
So the testing kit may not be very accurate.
correct,
This is
There are
one
limitations.
inference we can draw.
yes.
Secondly, 10 samples were collected.
Regulatory samples were.
Regular samples were collected. Out of that, 3 came to be positive,
Positive.
7 came to be negative.
Negative. And out of which.
And have you looked into what are the original source of the 3 positives and what are the original source vegetal of the 7 negatives?
Yes, yes, my lord, we have the details with us.
Can we take a look at it? Which source is showing positive and which source is showing negative? Which page do I look into?
It is annexure F, my lord.
Annexure F.
The details of the source is not placed here.
No, this is relevant because the source from which negative samples are coming, positive samples are coming, they have to be tackled.
The record.
See. Suppose source is X. X place is the source. Out of that, 3 has come positive. And you have collected 10 samples. If 3 samples have come positive from place X, it is only your sample. that place X must be manufacturing a huge other quantity other than your sample.
Yes.
They are also have to be presumed to be positive. So you have to hit the source. Otherwise, it's a futile exercise.
These three samples were all collected from Pamohi market and
No,
prosecution.
no, source from
So,
where
yes.
this vegetable, you
Yes.
have to investigate.
We have
If you
already,
need, you take the help of the police also.
we have already investigated
From
and prosecution
From
sanction.
where has it come?
It has
Who
probably.
is the producer of this positive vegetable? Can I have the name? Can you have the location of that person? Can you have the location of the agricultural field where it was produced?
At this point of time, my lord, do not have this.
Please
detail.
provide that information.
I'll provide that because prosecution.
Because unless, if you are serious to eradicate the problem, you have to act accordingly. If you are not serious, only a cosmetic show has to be made before the court. You can very well go where you feel like.
Because against these three samples were pesticides.
See,
was
Mr.
collected.
Officer,
Prosecution-
Mr. Officer, suppose today I am a producer.
Right.
That product is contaminated, it is positive. You have taken 3 samples from me. I must be having another huge bulk of the product with me. If 3 of my samples have come positive, that means the rest of the bulk is also positive. Have you taken any action? What I have
Yes.
done with that rest of the bulk?
Yes. ma'am.
What action you have taken?
Because we have already launched.
If you don't know the man who is producing it, if you don't know the locality where it is produced,
We
how
know,
can you take action?
my lord, we know because we have already.
No, just now you said I don't know, I have the
At this
information. Now
moment-
you are saying I have no.
At this moment, I cannot share the details because I do not have it with me, my lord. But against these 3 samples, we have already launched prosecution sanction against them. Commissioner of Food Safety has already issued give sanction. for
We are more
prosecution.
concerned with the balance of the bulk product of that producer. What had happened to that produce? Somebody had consumed it. Your sample which came positive, sample must be only a small amount of the entire bulk produce of that producer. What happened to the other bulk produce? Somebody must have consumed it. What had happened to that man who had consumed it? Are you not concerned?
We are.
Then that's why I said we don't want any cosmetic action. Today the matter is listed. Let me go with a bunch of papers, tell the court we have done this, we have done that. We're not interested with all those. We are interested with effective measures being taken that the problem, if you can, you eradicate it. If you cannot, you tell us we cannot do anything and surrender to the
My
society.
lord, there are
Lordship, on the next date, Lordship will furnish the original source, Lordship, from where
Tell
this.
us something.
Yes, Lordship.
And tell us what action
Because
we have
these are
taken.
only few things, Lordship, which you have collected. It's not the whole bulk. So, Lordship, and
And on a long-term basis, why could you collect only 10 samples? Why not 500 samples?
my lord, there are some
See-
samples have already been collected, but some reports are pending at the laboratory.
How many reports are pending?
Around 15 reports are pending.
15. So you have collected 25,
Right.
10 plus 15.
In Guwahati.
And how much vegetables are available in the city? Is it not even the tip of the iceberg you are trying to hit? And come back to the court and say these are our reports. And this is going on for the last 6 months now.
We will collect more, sir.
See, if this is your approach, you can never solve this problem. Tell the people of Assam that we are helpless, we cannot do anything. You face your own consequence.
We will, next time we will.
It's not next time. No, we're listing it day after tomorrow. Complete information. See, if the people who are indulging in this production of contaminated vegetable are not taken to task, they will feel encouraged. In spite of court monitoring, in spite of everything, no one can do anything to us. Let us go. Why will you give them that feeling? So you are in collision with them indirectly. Don't worry, mister, you carry on, we'll just show some cosmetic, we'll tell the court, we'll take care of your problem. You must have said that to the vegetable producers. Unless you are doing something. Only when you take effective steps, it will be a deterrent, then the problem can be solved, not otherwise.
Lordship will take more samples, Lordship, and will send it for testing, Lordship.
Do
10
something.
is 10 or 25 is quite less. Lordship.
People who are indulging it should have the message that something is going on.
Yes, Lordship.
Now, there's no message at all.
And
They must be laughing at you.
already, Lordship, this has gone for consumption.
Lordship, what it is from the report that the our atomic research kit has
It is of no use.
only.
That is almost ineffective, it appears.
They have in that, under that kit, Lordship, they have tested about 51.
51,
items.
71.
And all 50 are negative.
Lordship, so the.
So it's
regular
almost of no
process-
use.
Is there.
Regular testing process will have to be more. active.
You have to take samples by following the due procedure of law. Take the complete particulars
Yes.
of the person from whom it is seized, who is the producer, test it. If one sample comes positive, that means that producer is indulging in much more contaminated vegetable production. Take some effective steps. Or agriculture department, show them some alternative methods of producing the vegetables. You don't, that they have to stop doing everything. Show them, guide them. Have you ever thought about why they are indulging in this contaminated vegetable? Why? Why do they indulge? Their intention is to cause harm to the people, or their intention to have some undue benefit out of it? Which one?
Lordship, undue benefit.
Undue benefit. What undue benefit they get?
They want to make more profit with lesser, within a less period of time.
So if it is
That's right.
contaminated, the vegetable grows faster. Or what?
Looks fresh, Lordship.
Looks fresh.
Why your field officers cannot keep track of selected agricultural fields?
That lot.
You take a sampling of the agricultural field. Of course, I don't say that you have enough manpower to visit every field. Take a sample. Say X agricultural field. You let your official visit that field every day. Find out within how much time the vegetable is growing. Your statistics will reveal.
And Lordship,
If a cauliflower normally takes 15 days to grow, if in a given field it is growing in 3 days, that means something is wrong there. Why can't you be a little more proactive?
Lordship, I'll try to.
See, we are not agriculturists, but how can we have these ideas if you cannot, as the agriculture department?
Lordship, especially this.
If you think a little, if you come out of your comfort zone, that I only sit in my table and do whatever is minimum required to be done. Unless you don't come out of that comfort zone, how can you solve these problems? Can't your secretary, why he didn't have this idea? He's supposed to be a very high-ranking official. Why he didn't have this idea? Why it should flow from the court?
Lordship, I'll try.
Can't you do it? You say they are using this method so that the production is
Faster.
hastened. It becomes very fast. Keep track. And the report of the petitioner is quite against you.
That Lordship.
Can we have a copy?
They also say there is significant lack of awareness amongst the vegetable vendors regarding issue of pesticide. They don't even know. This is what we have done for the, and we say that there must be adequate publicity and make the people aware. The vegetable vendors itself don't know. That is their report. They made some field visits.
Lordship, I'll try to get the instruction.
What instruction?
No, the awareness, what type of awareness program they are initiating? in-
See, if you
whether
are,
it's
if
continuing
you are
on
serious,
the-
tell us. If you are not serious, file an affidavit, we'll close this matter.
Lordship, I'll try to get the-
Why should he spend our time for all this?
No, it's a serious issue, Lordship.
If you're not interested, file an affidavit, we'll close it. We'll tell the petitioner that courts are helpless, so we can't do anything about it. You go elsewhere. See, it's a problem of the society, it's a problem of the all the people. Medical reports are saying that the prevalence of kidney disease is increasing in this place because of this problem. Is it not a time for the state to be little more aware of their responsibilities? Yes, Mr. Agirji. See, whenever there is a court proceeding, there is two methods of doing it. Because even I have handled matter from the other side. One method is, let us get a word further today. Show the court we have done a little, this. Court will be happy, it's over. Next day it will be fixed, we'll think something more. Some better ideas on the next day. Other is, take note of the serious problem and show some earnestness in dealing with it. That is not forthcoming. That is not forthcoming. Definitely it's not coming. And see the report of the petitioner, go through it. We had a quick look at it. See, where there is a will, there is a way. It's the old saying.
Give me just 1 week time. I'll try to get the up-to-date information with regard to the awareness and.
No awareness, you'll show a few slides here and there. This one is done. We have put up in the TV on so and so their dates. Not that you are not done, you must have done. We are not saying you are not doing anything at all. Is it effective? And have you done a have you done something further to evaluate whether it is effective or not? I think that is lacking from
Maybe. Just to be more proactive.
some. Or else we are going to close this proceeding. We just will express our views, whatever we have to express. We don't like to have these officers also every day. We have many other matters to deal with. We'll devote our time for other matters. Forget about this one.
Lordship, may I make a submission?
Yes, please.
The commissioner.
Not only submission, something effective,
Yes,
what will
yes,
be
that's
done.
what- That is our intention, my lordship. We have been working towards it, but I admit that. there
See,
is some-
suppose in the morning at 10:30, I say, my intention is to complete the whole list. And at the 10:30, you'll find a time taken up only 2 matters. Do you mean to say I have any intention? In the 10:30, I'll make a statement. Today, I have the intention to complete the entire list. At 4:30, when you come to the court, you'll see that item number 2 is still going on. Does it have any value of my statement in the morning?
Actually, our commissioner of food safety, there are 2 equipments that are required for the analysis of.
What is
pesticide.
required?
There are 2 equipments, sophisticated equipments called LCMSMS and GCMS.
Once this is available, you can do everything.
We already have that, but we
Huh.
already have one set of this.
Hmm.
These instruments are taking care of all food articles, analyzing all food articles.
Achha.
So there is this system, these 2 systems.
So you need 2.
Yes, my lord. There
What is the cost of this system?
approximately 3.5 crores will be the total cost of this We have already, because in the last,
And where is the obstacle in procuring this? The sanction is not coming.
because last time Agriculture Department has agreed to probably, as per your direction, they have agreed to provide us this instrument. And we have already accordingly submitted.
Yes, where is the obstacle in procuring the equipment?
Lordship, only just now, while he submitted, I came to know that they have already submitted a proposal. Lordship, I will try to.
So if they feel that if one,
That
see,
particular-
if you consider the health of the entire state, 3.5 crores is not a huge amount
Yes,
to invest on that.
because these two systems will be dedicatedly will be used for vegetables analysis, my lord. That's why. it
So
will be
only when some, and mind you, the state has an inherent responsibility for the protection of its citizens. You cannot come out of that responsibility.
Lordship, I'll try to get the information of why, as what stage the proposal is. there, pending.
Why it is not moving forward? If they feel, of course, that
Yes.
if this is done, the problem will be taken care of to a great extent. If they
Yes,
feel,
that is what my humble submission to you, my lord.
Lordship, I'll get the information.
food and civil supplies have given their proposal.
Food Safety Department. Yes, we have
they-
already submitted a proposal to Agriculture Department.
Agriculture, when was it submitted?
It may be 2 months back,
2 months back.
more than that maybe.
You give that document to Mr. Chaudhary,
I'll provide. Lordship.
that your
Proposal.
that proposal of the food and civil supply, please give it to the council. He'll obtain the information on the next day.
Even then, without that also, Lordship, I'll try to get that.
Try to find out. And show us, file an affidavit showing us some more proactive steps, what you are going to do, precisely what you are going to do. We'll look into what you have done after 1 month.
Lordship, my humble submission, if Lordship gives a specific direction, then I can.
For
impress
what?
This steps, Lordship, then I can impress. upon
See,
more.
if you apply your mind, logically think on a problem, there are numerous solutions. If you don't want to do, there are numerous reasons not to do also. You can show 101 obstacles before you, why you are not able to do. But if you want to do, there are many methods of doing. It's all depends on your will, nothing else. And if your will is, let us get over for the day in the court, and after going out, say, for today it's over, don't worry. A huge sigh of relief. Then if that is your approach, of course, no one can help it. So what order should we pass today? You tell us, we'll pass it. Mhm. But don't you think it's a serious problem? Or it should be ignored?
So, Lordship, it's a very not only for us, for the future generation also, it will have an impact. Lordship made.
Have you noticed one aspect? The children that were moving around, playing around with you when you were a child, and the children of the present generation, have you noticed any difference in them?
Yes.
Just go back to your childhood memories. The numerous friends that you have been playing around with all the time, spending the time, how they were, and the children of the present generation, how they are. Do you see any, notice any difference? Hmm. Why is this difference? Is it only for that TV culture and couch potato and doing nothing, or something more maybe also there?
Food also there.
Hmm.
Because the food habit that we have.
Don't you think it is the responsibility of this generation to also take care of the problem, so that your future generation is better? Or we have no responsibility?
We have.
Judicial. It is stated by the Food and Civil Supplies Department that out of the 10 samples that were collected, 10 samples of vegetables that were collected, 3 of those samples had showed positive results for contaminated substances, contaminating substances. 15 results are yet to be received. It is also stated that the test kit that were procured from BARC appears to be not that effective, in as much as some of the testing done through the test kit had showed negative result. But later on, when the regular testing was made on the same sample, positive results were shown. What is that system you were saying, that name?
LCMSMS and
You have one,
we have one set of LCMSMS and
and you
GPMS.
want the second set.
Yes,
And for the first set, what is the capacity of that set? How many samples it can handle? Say within 1 week, how many samples it can handle?
Milord, this system works 24/7 because there
No, we are not on that. What is the capacity of this system? How many samples it can handle in 1 week?
in 1 week it may analyze around 120.
120.
Yes.
It is stated by Mr.
Anupam Gogoi.
Mr. Anupam Gogoi, you are the secretary,
I'm food analyst to government of Assam.
the food analyst to the government of Assam, that there is a testing system named
LCMSMS
LCMSMS,
and
which is,
and there is another Milord.
and then just one by one,
Yes.
which is available. And that system has the capacity to test about 120 samples of vegetables per week. It is stated that the Food and Civil Supplies has one such system, and they have sent a proposal for another such system to the Department of Agriculture, but no response has been received as yet. If the second testing system can be procured, it is expected that about 240 samples of vegetables can be tested per week. Now, what is the other system?
LCMSMS and GCMSMS.
It's stated that do you have that?
Yes, we already have one each of.
It is stated that there is another testing system called GCMS,
MS.
which also has the capacity of
Equal.
about 120 samples per week, which is also available. So if you make optimum use of these two samples, you can test at least 100 samples per week.
Milord, the problem is this, that we are simultaneously also, this system is taking care of other categories of food products. Because there are so many
Understand.
important, yes,
So how much capacity you can spare for vegetables?
because this,
No.
this
If it is taking care of every kind of product, for these vegetables, how much capacity can be spared?
it is, Milord, it's difficult to say, but it is around 40 we can do now.
Each system 40,
Yes,
so 80 a week.
no, 40, because the system, Milord, may I just explain? Because this, there are around 233 pesticides in total, which are screened for a sample of vegetables. Out of which 192 is screened by LCMSMS and remaining are screened by the GCMSMS.
Okay, so both system has to be used for the same vegetable,
Yes,
same
yes,
sample.
yes.
Very well. So capacity is 120.
So what I'm proposing, my lord, is that if I get another set of LCMS and GCMS, these systems will be dedicatedly used for vegetable testing.
It is also stated by the Food and Civil Supplies Department that the aforesaid two systems, the LCMS and GCMS, are used for testing all kind of food products. And therefore, out of the total capacity, only a part of it can be used for testing of contaminated vegetables. It is stated that out of the
33.
233 known pesticides that are to be tested, 192 are to be tested by the LCMS SS system, and the balance 39 system are to be used by the GCMS system. In other words, for a given sample, both the systems are to be used for a more effective result. In the circumstance, it is the submission of Mr. Anupam Gogoi, the food analyst, that if another set of the LCMS and GCMS are made available, the same can be dedicated for testing of contaminated vegetables, and in such manner, the testing system will be more effective. The response of the Agriculture Department to the aforesaid proposal of the Food and Civil will be informed to the court on the next returnable date. And if there is any impediment in procuring the two systems, what would be such impediments which would be insurmountable considering the public utility of such systems? Anything more? We have also taken note of the field report submitted by the petitioner as per our earlier direction dated 23/6/2023. Paragraph 5 of the report is extracted below, which is self-expressive, and departmental authorities are directed to take note of the said paragraph 5. Of paragraph 5, say paragraph 5. If 3 of the samples that have been tested were found positive, Agriculture Department to inform the court as to what effective steps have been taken to control the marketing of contaminated vegetables from such source which were found to be positive. A sample had tested positive means that there is another balanced bulk production of the same producer which are also contaminated but may have found its place in the market by now. Agriculture Department to file an affidavit stating the precise effective steps that they intend to take immediately after a sample is tested positive and the results are made available to them, so that not only the sample, the balance of the bulk produce, which may also be contaminated, do not reach the public for its consumption. List next week. We are putting it next week. Next Tuesday. Okay. Monday, did you? Wednesday? 16th. Why? Okay, 17. But you discuss with your high officials in the department. No, they can easily monitor. And Place some field teams and selected agricultural fields.
Lordship, they have formed field team, but what action?
What they are doing.
Yes, Lordship, it appears that Lordship not much progress has been there. Lordship, that I will try to infer upon them because what action they have taken from the date of formation of that team till date. Okay.
See, if these harmful chemicals are used, that the vegetables grow up very fast. Why can't you monitor that in your selected fields? Go to that field every day.
Yes.
Take measurement of the vegetables, sample by sample. If you find it is going faster than the normal rate, that means something wrong is there. Test it immediately there and there in the field itself. And also wonder what are the sources of these contaminating substances? Is it freely available in the market? Or it is regulated?
Lordship, normally it is regulated, but even then recently on we were also making some dates, lots of some licenses were cancelled.
Out of 1,001 license was cancelled. 999 are still there.
While doing that, it appears from the cases and the documents that were produced that there were lacuna while
So
suspending us. So it was ineffective, Lordship.
So
Yeah.
they make it effective.
Yes.
If necessary, you form a joint team comprising of the agriculture department, food department, police department, and any other department you want. So that joint team will have a jurisdictional power to take all kind of steps.
That direction Lordship has already given earlier. To take assistance of any other department that is required.
Now you form a specific joint team of all the necessary departments, and that joint team will be responsible henceforth. If they are not doing it, is their responsibility. Their dereliction of duty. The agriculture department to also file the affidavit on the next date, stating as to whether the contaminating chemicals are freely available in the market or they are regulated, if regulated, in what manner, and to what extent the free availability of such chemicals can be controlled, and what effective steps would be taken to do so. List on there. Hold on, now spouse gold, thank you. Hold on, now spouse gold. The report submitted is kept on record. So, delicate.
Item 3.
Yes.
Reasons. This yellow asks me to the report.
So
of
it is
the
gone.
report of the statement is contradictory. That's
Yes.
Ask my petitioner. why
See,
he
no,
has-
no. Police has reiterated that you told them that you came from Bangladesh. Number one. Your father made a statement in the proceeding against him that he came from Bangladesh. Now here you are taking a stand that I told the police I came from Azamgarh, but the police is wrongly writing in the report that you came from Bangladesh. Why have you made a false statement before the court?
That's why I have asked the petitioner. Why he has made, it said that.
No, why are you trying to mislead the court? Why are you making false statement before the court?
Because he said that he's forgotten about the statement.
Sorry.
I asked the petitioner why it make this type of contradictory statement. The father said that he did that at the time of come to Kokrajhar, he was child, 3-4 years. He was a very young child, 3-4 years. age.
So he was 15-4-year-old child, so therefore he made a wrong statement.
That is not. He said that, but he heard that he's from his father, that they have originally from Azamgarh. But documents is there, the 70, they have come to Kokrajhar totally 70, father's name is there.
So, but you had told the police wrong statement. So we dismissed the petition for trying to relying on false statements.
It's a illiterate person.
Sorry.
Illiterate person.
Where is the law that illiterate person is entitled to make false statements before the court?
No, yeah, there is. It is, I have.
So tomorrow all illiterate
No,
person
no,
will need only one license. They show that I have no education, I can
Yes,
make false
that's-
statement anywhere I
And
feel like.
person why he has made, because the documents is there, he should not make the false statement. on the evidence. He is looking there.
Lordship may go on merit if in merit he is successful, it can be accepted. Otherwise, this will be a
No,
contradiction of facts, man.
Mr. Islam. This issue of Azamgarh and Bangladesh had been going on for the last 3 or 4 days. Had you been fair enough, you could have straight away said, let me go and consult my client, whether he had wrongly stated or not. The statement you are making today would have been made about 3 or 4 days earlier. But you insisted.
No.
Not only insisted, resulting in an inquiry by the SP to be conducted. Because your allegation was against that particular inquiring police. That he is deliberately writing wrong statements and not writing what I am saying. And that's a serious allegation against the police. You face the consequence. It's a penal offense. Making false allegation against a public official on duty is a penal offense. Face it.
Very dear. Because he won't approach me yesterday also I talked, because I should make his tongue.
No. His behavior as of yesterday, why you could not be on about 3 or 4 days earlier. 3 or 4 days earlier, you were vehemently saying before the court.
Because I also.
You are not only that, you are raising accusation against the police, which resulted in a judicial order to make an inquiry. So after doing everything, now will your statement today be accepted? We'd have accepted on the very first day, we'd have accepted it,
Is correct.
but not today. Today, the situation has gone a little further.
That is, earlier he has said that he stated before that he's from. Azamgarh.
No.
Now when
We
I
are not on stating. We are on your conduct of raising false accusation against the inquiring police.
Because
What
last,
about that,
last section when I verified that documents, his father is still also there, when I saw him.
Mr. Islam? Give the answer on your false accusation against the police. Because you reiterated. Had that day you had made today's statement, we would have accepted it. That yes, inadvertently somebody said that. But you said no. You went on reiterating, compelling the court to make an inquiry.
Yes, that's right.
And when the inquiry report is against you, now you are withdrawing from the thing. That we cannot accept. File your affidavit. By the order of 26/7/2023, the petitioner was required to explain the inconsistency. To the extent that the petitioner was reiterating repeatedly that he had stated before the police that his family came from Azamgarh, but it is the police, in spite of his statement, had wrongly recorded that they have come from Bangladesh. In other words, it's an accusation against a public official for having deliberately written the statement of the petitioner in an incorrect manner. The explanation be made in a form of an affidavit list also. Don't do it. And don't be so casual. And I don't think this one may not be the view of the petitioner. It may be some legal advice also.
Item 4.
May I please your lordship? Your lordship may look into your last order dated 17.
Material show that Gulapi Mondal is the daughter of Jyotinra Mohan.
Lordship, lordship, as per this order, we have already informed the petitioner to furnish those relevant documents. So lordship, they have not informed us anything, so we need some more time.
Some more time, how much time?
Lordship, 1 week.
1 week. It is stated that the petitioner requires a further week's time to produce the relevant materials as required by the order of 17/7/2023. Prayer law.
Highly obliged.
Item 5.
My lord, in this case, my lord, I seek only 3 days time, my lord. If it is ready, my lord, I was directed to file an affidavit by the president of Gram Panchayat, my lord. The affidavit is ready, but it was signature is, my lord, awaited, my lord. So it will come tomorrow, my lord. It is 3 days time may be granted, my lord.
Mr. S.S. Rahman and the petitioner seeks for
3 days time, my lord.
3 days time to file the affidavit as required by the order of 22/6/2023.
All right.
Prayer law. Let's see.
Item 6.
Legal lordship. My lord, parents are voter in 1966.
Page number?
Page 23, ma'am.
23.
23, 24 is the vernacular. Nasimuddin, grandfather.
Nasimuddin is the grandfather.
Aisha Khatun, grandmother. Mahmud Ali is the great grandfather. Then my lord.
Aisha grandmother.
Yes, ma'am. Then my
And
lord,
Mahmud Ali, it's okay, 66.
Page,
Borovita.
page 26.
Now who is the father?
Father is my lord
Amjad,
Amjad Hussain at page 27.
27, 89.
Yes, madam. 20, 89 total list. Amjad Hussain,
Father. Jamon Nessa is the mother.
mother.
And
Then my
who
lord,
is the petitioner? Moinal
petitioner,
Haq,
lordship will find at page 29.
29.
He is with, his voter with his parents, but in same village. Now, my lord, I have also one Jamabundi copy.
Where is it? Page
My lord,
number?
at page 41, a vernacular portion. Page 42, 43. Father got land from grandfather, my lord. So thereby, my lord, the direct linkage.
Jamabandi, Borovita,
What we-
Nasimuddin.
Yes, madam. Nothing is
Amjad.
at serial number 1. Father's name is at serial number 11. So order of 6 to 1996.
96 okay, order. Yes, Mr. Pai.
First of all, my lord, you'll also make kindly city voter list of 1966. There Nasimuddin Aisha Khatun is there. Next, in 1970, Nasimuddin Aisha Khatun Kamaluddin is there. But my lord, the 89 voter list.
Just a minute. 66, Nasimuddin Aisha Khatun.
Yes, ma'am.
Yes, then
Next, my lord, page 25.
Nasimuddin Kamaluddin. Yes.
Nasimuddin Kamal. But nobody from their family, my lord, in the 1989 voter list. And the petitioner is 40 years in 1949, 89. my lord.
Hmm.
So if somebody is there, my lord, somebody of this 1970 voter list should have been there along with my lord, this voter list.
Sorry.
Somebody from 1970, my lord, Nasimuddin, Aisha Khatun, Kamaluddin, whoever it may be. They should have been there in 1989. Oh, my lord, the
1989 is the complete voters list. How do you know that they are not there?
no, my lord, this is their documents, my lord. I
Not
don't
their
know
document.
about
This is what is given to them.
This is, my lord, on their.
So if you want to make that argument, you produce the complete one, raise your argument.
And secondly, my lord, Amjad Hussain is 40 years in 1989. He should have been there in 1970 also.
Suppose
40
it
years.
is not there then. And even those 70 and all are also not the complete.
Yes,
And Amjad Hussain is 40 years.
40 years in 1989. 40 years,
1989.
yes,
So in 1970, he is 20 years.
20 years.
Hardly 2 years above majority. His name may not be there also.
20 years, 20 years.
See, Mr. Paying, our system is not that perfect. That everything that ought to have been always happens. This is the difficulty. The difficulty of accepting the argument of ought to have been like this, because system is not perfect. Had it been perfect, you are very right. Suppose the man becomes 18 years, very next day his name will appear in the voters list. If had the system, you are right. It should have been there, but it's not like that.
My lord, let them explain or bring this full, my lord, the entire voter list of 1989 or 70, my lord.
Yes,
And
let him produce the entire list if you want. That we can agree. No?
Because what happened to parents and mother and father, that in between.
See, Mr. Paying, the lawyer who will be handling the tribunal may not have the same legal acumen what Mr. J. Paying is having. If everybody would have been the standard of your legal acumen, maybe they would have taken care of this problem. Everything is not like that. And you have to also take note of the ground reality. You can't expect the ground reality to be an utopian in a European situation and then say. But if something is not there, you tell us that this is unacceptable, this is wrong, this is, we'll definitely hear you. Third, Mr. A.R. Sidal for a petitioner. The petitioner Moinar Haq had been referred to the Foreigners Tribunal number.
বঙ্গাইগাঁও 2 মানে একটা ওয়াইবি পেশ করতেছিলাম
To the Foreigners Tribunal number 2 Bongaigaon at Ovaipuri for rendering opinion as to whether he is a foreigner. The tribunal rendered an opinion dated 6/8/2019 declaring him to be resulting in registration of case number so and so. Tribunal rendered an opinion declaring the foreigner being aggrieved, a state petition is instituted. You need to hold NOC, tenancy, behavior, particularly.
In fact, we are trying to read the tribunal order.
Because we have suddenly developed interest in the orders of the tribunal. Come to page 48. That second last paragraph in exhibit 6, because the rest is all nothing, nothing relevant. OB claims his name is recorded with his projected father. Exhibit 6. What is exhibit 6?
Exhibit 6, my lord.
Go to the page, previous page. Voters list of 1997. The name of voters are Ajmal Hussain, HOSEN, Jaigun Nesan, Moinal Haq. It is seen that no document brought on record for establishing existence of OP's projected father Amjad Hussain in Indian soil prior to 89. OP though claimed that his grandfather's name is Nasimuddin and his name recorded voters 66 and 70, exhibit 2 and 3. These documents are not sufficient to establish linkage between projected father Amjad Ali Hussain and his grandfather conclusively. Why?
What my
No, what more the tribunal wanted? Let us have an affidavit for the tribunal. What more the tribunal wanted?
probably my lord, what I have submitted, that what the tribunal wanted to say.
What?
If the my lord, the 89 voter list contains the name of any one of the my lord 70 voter list.
So let the tribunal file an affidavit and we'll put it test with the election commission that these are maintained so immaculate manner which will be sufficient to draw a adverse presumption against these people. Find it.
Tribunal, but
See,
the home department.
See, if you rely upon a base to derive your concepts, the base must also exist. A presumption of the existence of the base will not allow you to draw a particular concept if the base actually does not exist. What is the existence of this base? That the lists are maintained in an immaculate manner. Day the man becomes 18, the next day morning he'll get up and find his name in the voters list. Spellings are written in a most correct manner and meticulous attempts are made to ensure that the spellings are correct. Age, everybody will calculate. In 66, you are 40 years. So therefore, in 71, it will be 46 years. No one is there in the election commission to write it to be either 44 or 48. We don't do all this. This base must be there to draw this conclusion. Understood what we are trying to tell you? Yes, conceptually, this is a very right approach. provided the base upon which this concept is developed exists. If it does not exist, then what do? You go a little further, find out through some other materials. Then say, apart from the discrepancies in the name of the project father, OP neither discloses his mother's name. In Sarvabanda Sonwal, it is held to establish once a may be required to give evidence of date of may be required, that one. Date of birth, place of birth, name of his parents. So the name of the mother is not stated, so you are gone. Did Sarvasanda Sonal judgment mean this? May be given. Maybe means you can give either of the two also. Or if necessary, you give it. And was it not prudent for this tribunal to ask that question? That if he so follower of this one line of Sarvasanda Sonal, what is the name of your mother? Could have asked it. Don't they have any duty and responsibility for that also? Now, discrepancy in the name of the projected father. Why? Come to page 27, Amjad Hussain, HUSSAIN. 29, Amjad Hussain, HUFEN.
Amjad, DNC.
And 27, father is Nasimuddin, and in 29, he is Nasim. Again, back to the same concept. Is the base so immaculate that they are writing it correctly? So because the election commission is not writing the names in a most meticulous manner, so therefore a person loses the right of citizenship.
One issue you'll also kindly see.
Well, a rejection of exhibit 8.
Mhm.
Rejection of exhibit 8 is also very interesting, my lord, in page 249. Jawamati is disbelieved because no self-purchasing deed could not be put. It is not produced, my lord.
এইটো ঠিক কৰিব লাগে হেৰিটো এইটো কমাই দিব লাগে এইটো কমাই দিওঁ নেকি Good. Mr. A.R. Sigdar, Learned Counsel for the petitioner. Checking before the tribunal, the petitioner. Before the tribunal, in the writ proceeding, the petitioner relies upon the voters list of 1966 of village Borvita, Moza Titapani in the present Borpeta district, which contains the name of Muhammad Nasimuddin, son of Mahmud Ali, at serial 40, and that of Isaac Khatun, wife of Muhammad Nasimuddin at serial 41, and both are residing in the same house number 19. It is claimed that Muhammad Nasimuddin is the grandfather and Aisha Khatun is the grandmother of the petitioner. The voters list of 1970 of village Borvita contains the name of Nasimuddin, son of Mahmud Ali at serial 46, and Aisha Khatun, son of Nasimuddin at serial 47, and both are again shown to be residing in the same house number 19. But the 1970 voters list also includes the name of Kamaluddin, son of Nasimuddin at serial 48, and it is stated that Kamaluddin is one of the sons of Nasimuddin. Thereupon, reliance is made on a voters list of 1989 of village Borvita, which contains the name of Amjad Hussain, Sussain, son of Nasimuddin at serial 43, 149, and Jaimun Nessa, wife of Amjad at serial 150, and both are residing in the same house number 43. It is claimed that Amjad Hussain is the father and Jaimun Nessa is the mother of the petitioner. The voters list of 1997 of village Borvita contains the name of Amjad Hussain, Sussan, son of Nasim at serial 182, Jaimun Nessa, wife of Amjad at 183, and Moinal Haq, wife of Amjad at 184, and both are shown to be residing in the house number 64. Reliance is also placed upon an order of the, where is it, Jamabandi?
My lord, at page 41.
41. Reliance is also placed upon a Jamabandi in respect of a plot of land at village Borvita, which contains the information that land had been mutated in the name of Amjad Ali, son of Nasimuddin, in place of Nasimuddin, son of Mahmud Ali. And the mutation had been effected as per the order of the circle officer dated 6/2/1996. What happened to Kamaluddin?
My lord, I think he has expired prior to this order, my lord. I have no specific instruction. My lord.
He was there in 1970.
Yes, he is not available. Subsequent.
It is noticed that in the Jamabandi, it is Amjad Ali, son of Nasimuddin, whose name had been mutated in place of Nasimuddin. But at the same time, another son of Nasimuddin is Nur Hussain, whose name had also been mutated in place of Nasimuddin. Why do people always keep on changing their surname? Wherever you feel like you become Ali, wherever you feel like you become Hussain. Why? Why can't you be satisfied with one name for one life? Why need more number of names? And this is creating all the problems, and he's and they're raising it.
Mohammedan, my lord, there is no Gutra system, and the father
Sorry?
can. In Mohammedan, my lord, people, my lord, there is no Gutra system. Son can write a title differently with his father.
You write,
And therefore, these things are going on.
Mr. Sigdar, you write any surname you feel like. You don't need a Gotra system for that. Why are you not satisfied with one surname? This is what we are asking
Yes,
you.
my lord, that is the.
If you want to abandon Ali and Hussain, suppose one write Ahmed also, you write Ahmed. No one is stopping you. But why can't you stick to Ahmed for the whole of your life? Wherever you feel like you become Ali, wherever you feel like you become Hussein, wherever you feel like you take some other name, and then come and say it's the same person, and they will raise the objection. It's a difference in
That
name.
is the situation, my lord.
It's a self-created situation.
Petitioner also shifted in the meantime, my lord.
Hmm.
He is a resident of Kahibari, my lord. At present, he is a resident of Kahibari. He is not resident of Barbita.
That
Petitioner.
we'll put this question open. It is sought to be explained by Mr. A.R. Sigdar that in the Mohammedan community, they can write any surname, and it is not mandatory that the surname used by the father would have to also be adopted by the son. But that doesn't mean Amjad Hussain, for the purpose of voters list, will write Amjad Hussain, and for the purpose of mutation, we write Amjad Ali. Writing of two different surnames in two different documents definitely would give rise to a cause of action for the respondents to raise an objection that they may not be one and the same person. The aforementioned materials had been dealt with by the tribunal in its opinion dated 6/8/2019 in the manner as extracted. Red to red, দুটা আছে। Page 48. Whole দিব নালাগে। A reading of the afore extracted portion of the opinion of the tribunal goes to show that the voters list of 1966 and 1970 of village Borbita, which are exhibited as exhibits 2 and 3, which contain the name of Muhammad Nasimuddin, was found to be not sufficient to establish linkage between the projected father, between Amjad Ali, alias Hussein, and his grandfather in a conclusive manner. No reasons are forthcoming from the tribunal why the tribunal had adopted the same view, or what was the standard of sufficiency that the tribunal expected in the present case. Further, the tribunal was also of the view that there are discrepancies in the name of the projected father, and the petitioner did not disclose in his written statement or in his evidence, did not disclose the name of his mother in the written statement or in the evidence. Full stop. The Exhibit 8 Jamabandi was rejected by giving a reason that no statement was made in the written statement regarding the purchase of any land by the projected grandfather in the same village. The reason for not accepting the voters list of 1966 and 70, that these documents are not sufficient to establish linkage between the projected father Amjad Ali alias Amjad Hussain and his grandfather in a conclusive manner, has already held, is devoid of any reason or as to what is the standard of sufficiency that is expected by the tribunal. If the voters list of 1966 and 1970 is of the same village, as that of the later voters list, which contains the name of the father of the petitioner. Full stop. Unless sufficient materials are produced before the tribunal by the respondent authorities, that although the name of the father projected in the later voters list and the name appearing in the earlier voters list of 1966 and 70 are not one and the same person, we see no reason as to why the voters list of 1966 and 1970 is not to be accepted by the tribunal. If you have materials, that Amjad son of Nasim and Nasim in 66, if somebody produces material that this Nasim and that Nasim is a different person, you have no reason to discard it.
My lord, we have some judgments on these issues, my lord.
Produce.
Can it be fixed day after tomorrow? my lord?
No, we are in the middle of the order. You should be ready. But which judgment?
Of this honorable court, my lord.
Which judgment? Let us take a look, find out. That says it should be rejected. Let us see what is the reasoning.
With regard to the voter list, my lord, inconsistency of the voter list. my lord.
There's nothing inconsistency. Inconsistency you reject. This is consistent.
Can it be fixed by 2, my lord? I'll
No, to be some other matter or other matter. Tell us which judgment says that in the later list, the name of the father, and in the earlier list, the same name of that father appears, is inconsistent. If you only stand you can take is that this man Nasim and that man Nasim, they are not the same person. And that is the material have to be produced by the state after your inquiry.
My submission was that, my lord. This what the
No, I will deal with today. We are taking up the matter in detail. We deal with each and every submission of yours. Please make your submission.
my lord, the voter list of 1989. The petitioner nowhere stated in neither in the WS nor in the my lord evidence what happened to parents.
Why should it be?
Grandparents,
Why should it be stated?
No, my lord, because
No, why should see? Only relevant facts are required to be stated,
there is a
not-
relevant fact, my lord.
not the entire facts that can be imagined by the opposite side has to be stated.
Understood, but
No.
what's your lordship? My lord, my
Then next time you say he did not state what color clothes the grandfather was wearing at the time of his
why
death.
necessary, my lord?
You
Because in-
say raise that also
my lord,
today.
why necessary, my lord? In 89, the grandparents are not there, neither the grandmother, nor the grandfather.
What is your basis of saying it is not there?
No, in 1989, voter
What
list,
is your basis of saying they were not there?
in their exhibit, my lord, it is their documents, my lord. They have exhibited this document and giving.
So
you
if you want to counter that, you produce your exhibit to show.
my lord, it is their duty to prove
See,
it fast.
you will do nothing.
Obviously, my lord, we will do, my lord. We are not saying that we will not do.
You could have requested, if you want to raise this objection, request the election commission, give me the complete voters list. I want to raise this objection. Need to do that? No.
That is-
Okay.
my lord, it is their duty. They
No,
could
it is
prove-
not
they-
their duty.
They could
Sorry,
submit the entire. voter
Sorry,
list.
we are going to pass the judgment on that. It's going to be little difficult for you from now onwards. It's not their duty.
Otherwise, my lord, it will be difficult for the tribunal because tribunal is the my lord, neutral authority. They cannot
No.
do anything. They cannot presume.
Definitely cannot. You raise all your arguments. Yes, we are also video recording this one. We'll take note of everything. You say what you have to say.
My lord,
Yes.
my submission is that, my lord.
Your submission is
In 18
only
19
one, not only today, Mr. Paying, your only submission for the last 6 months have been till I am satisfied, you'll have to go and bring in material and material. I am holding a whip in my hand because you were a proceeding before the tribunal. There is one section 9. Till I utter the word, I am satisfied. You have to go on bringing material after material after material.
My lord,
And unless I don't say, you are a foreigner.
I want only one materials matter. If my learned friend or whatever may they bring, I'm
File an application, will call for it.
yes. The 89 voter list, the
File an
full voter
application.
list of 1980.
This is pending. You
Yes.
could have filed an application that for my argument, I need the complete voters list. Kindly issue direction to produce it.
And
Did
in
you do
between-
that?
In between voter list of 1970.
Everything, every material in the world, you will get it, but you must claim for it.
Yes. And second thing, my lord.
You can never raise a question without claiming a material.
And second thing, my lord, what my submission was that, well, the projected father whom the petitioner has said as father, my lord, this is Amjad Hussain, whose name is in the voter list of 1989, which the friend is relying, my lord. If we see, my lord, his name should have been there in between 66, 70.
Now you file an affidavit that the election commission is maintaining an immaculate voters list.
And
We'll accept it.
so,
Don't go on repeating. We deliberated on that point
Yes.
some time back.
so. There are
It
two
ought to
points.
have been, you are right. Because in 1966, this man would have been 20 years, his name ought to have been there.
1969, he's 21 years, as per the, my lord, his
Understand?
statement.
It ought to have been there, you are right. But if it
Yes.
is not there, then the basis of your concept is they are retaining the records in an immaculate manner. System is such, a person becomes 18 years,
21 years at that time.
21 years. So then you fall through, you would have been 20 years on that day.
No, 69, he's 21 years, as per the, my lord,
69.
yes.
69, there is no voters list.
No, 69, 70, 71 voter list, his name should have been there. In 69, he became 21.
So very well. So every citizen gets a birthday gift on the day he becomes 21. His name appears in the voters list.
My lord,
He gets a communication from the election commission with a slip. Here is your name, here is your serial number.
my lord,
Is
at
it
least
so?
one document where Amjad Hussain is standing, my lord, in together with Nasimuddin. The voter list, my lord,
If it is not there, what can they do?
my lord, the
Again, you are repeating, Mr. Rai, instead of entering through this door, now you are trying to enter through the other door. Again, the base concept is they are maintaining an agreement. So, Mr. Ali, are you maintaining your records in such a immaculate manner? File your affidavit, will appreciate Mr.
What they are saying, the basis of electoral is clearly, lordship, whenever a person attains majority, after he files a form, under rule 6, there is a form 6, they apply and their name is entered when they give.
Suppose somebody is late by a few years in applying.
There is no pardon process that he will, on the very day he will become 21, he will have to. But it is his, this is right, as per the constitutional right, he will, the day he will apply for the commission will enter his name in the electoral and he will, can have the right to exercise franchise, your lordship.
This is the fallacy of your argument, Mr. Understood? So therefore, your argument is a negative argument. This is not there, that is not there. So therefore, reject everything. This is a negative argument. Make a positive argument. Yes, I had used my authorities to make a verification. And my report is, this Amjad Hussain is not the son of that Nazimuddin. Straight away will dismiss the petition. Do it.
That is an issue, my lord.
That,
We are
no,
taking
that is
up.
not the issue. That is a requirement of law.
We are taking that up, my lord.
There is a dereliction of duty by these authorities. That is what is happening. Nothing else.
But my lord, only my question, even in the, my lord, the mutation order, as your lordship has seen, the father
have
has
observed.
been observed.
See,
So at least one documents linking father and grandfather, then everything is okay.
where we are getting it, we are observing everything.
Yes. Otherwise, but the link between the grandfather and
So,
father is,
yes, in other words, you have to do a little more work. Comfort zone is over.
At least, my lord, one statement from my learned friend. What happens to grandparents in between, my lord, 71 to 89, my lord? What happened to grandparents?
Did you raise it in the tribunal?
Probably it is
No.
not raised, but my lord, they have.
Then,
not raised.
if you have not raised it now, where will the materials be there? Had you raised it, he would have answered.
That should have been there, my lord, by the petitioner. themselves, because
Ultimately,
it
that's
is
why
their-
I'm saying these proceedings are conducted in a half-hearted manner. That's all. That's why you don't have the material. Number one. Suppose you call the proceedee to have submitted a written statement. You use the word written statement. Written statement is from the CPC. It's a concept of CPC. What is a written statement? When the plaint is filed to counter the averments in the plaint, a written statement is filed. Here is a case, there is no plaint. The pleading they are required to file, you call it written statement.
In fact, the
Number one. They don't know what kind of objections you are going to raise. At the stage of filing, are they aware what objection Mr. Pying is going to raise? He is not aware. In the absence of being aware as to what objections may be raised, he will file written statement only on the basis of what maximum he can think about in his case. Today, further down in the proceeding, respondents raise one issue that this is not there. So he had not filed in a written statement. Had it been made known to him that, yes, the particulars of the death of the parents are also going to be an objection, he would have provided it. But where is the occasion for him to provide?
This is
Unless you give him the occasion to provide the material, from where will he produce the material?
My lord, this is a special knowledge known to them. The state cannot. get
Mr.
those
Pying,
things from there.
Mr. Pying, this is an irrelevant consideration, only your objection. When the parents died. If you find relevant consideration, you ought to have raised this objection, given him the opportunity to produce that material. In spite of that, if he cannot produce, then we are ready to accept your argument. Imagine yourself on the other side. Mr. Pying, you imagine yourself on the other side.
Understood.
Today, you are called upon to submit a pleading without knowing what kind of objection may come in this case. What will he do? He'll provide only the general perceptions that he have in that. So therefore, there must be a system in the tribunals that what we have in the High Court, that will give you this ideal situation to argue. We have writ petition, we have affidavit in reply. Consider the written statement to be the writ petition. The state will file your objection to it. This is not there, that is not there, whatever is not there. Let him file a counter reply to that and bring in all the materials. In spite of that, if they cannot, then you raise this. He doesn't have it. Then it will give you a right. But otherwise,
That can be.
are you not taking them to an uncertainty? You are asking them to prepare a defense, you don't know from which side the attack is going to come. Only when he knows from which side the attacking comes, then he can take the defense for that attack.
My lord, let it come, my lord. If I'll get the full in between voter list of 1966 to 71. My lord, if My lord, not finished, that's the denied, my lord, we can say, my lord, in between this may not be.
Okay,
there.
to list for further, you file your affidavit then. The respondents in the Home Department to file their affidavit raising all the objections they intend to raise. List Friday. Then we'll give them another opportunity to file their reply to that.
Can it be met on Monday, man?
Do it fast, Friday.
Affidavit has to be filed, so.
Nothing great. Today is Tuesday only.
It will take
I was
some
thinking
time.
of keeping it for tomorrow because we have heard it. We can't keep it pending after hearing the matter. Then in every writ petition, you develop the habit of filing affidavit then.
Yes. Some cases we need.
If you want to raise these kind of issues, you file affidavit. Once you file affidavit,
Yes. they may also
he'll have
file
an
it.
opportunity to give reply. In spite of that, if he cannot give, then of course, presumption will be against them.
Earlier in some cases, we used to file it affidavit.
File in all cases. Actually, what ought to have done in the tribunal itself,
Yes, that should have been done. in-
that would have made the whole proceeding more complete so that he can take some decision.
That could have been done, that.
Otherwise, now what is happening? You are this side, so you are very happy to raise this objection. Stand on the other side, one day you'll realize the difficulty. You are expecting pre-existing material, pre-existing pleading on something, they don't know what you are going to say. You may say anything. You'll open your brief. Thought will come to your mind that this is my objection and throw it against him. It is not there. So your imagination and his imagination may not be at par. And same is happening with the tribunals also. This is not there. Then we streamline.
That could have been, that can be done in the tribunal itself, but we don't have the proper procedure, my lord,
No,
Later.
then we'll introduce the system of
filing reply and etc.
don't use the word written statement. There is nothing called written statement.
It
Pleading.
is, in fact, it is said, my lord, representation as per the, my lord, the act.
Definitely. Pleading by the proceeding, objection by the Home Department on every such pleading, a counter reply to that. So they also know what material is required to be produced.
Then it will be very clear. my lord.
Then you go through all this. And in the pleadings, you also annex all the exhibits you want to rely on. Annex it, then only, so they can read and file a reply. Should you pass such an order?
Let us
I
discuss.
think it will be better for both the
Yes,
parties.
Both the parties. Let us have a deliberation on that issue, my lord.
But now,
Otherwise, it's a,
that's why I say, think about the problem standing on the other side in one case. You realize it.
that will give a clear picture. Let me come.
Otherwise, it's become almost a never-ending business. Also, we are saying in the middle of the order, you always have the habit of raising objections. How will you expect the court to function?
That was my.
Why at the time of middle of the order?
I will do that much.
And if you're so perfect, are your system working to that perfection? There are loopholes everywhere. But when the orders are dictated going slightly against you, start raising all kind of issues. When it is a
So before the terminal. We have not closed the order.
Anyway, we are going to hear you this matter.
Yes, that's
Complete. Let's settle the whole issue of this thing. Because we can also take another thing, that no objection of this nature was ever raised. So we decline to hear you this objection. Why can't we do that? Why state should always be favored that whatever they say has to be decided? And that to objection based on imagination, which was never imagined in the earlier stages of the proceeding. There is a principle, you cannot take the other side by surprise at any stage.
That's true.
You'll have to give complete opportunity. If that's an issue, raise it. They'll produce the material. If they don't have, then of course it's a matter of different. It'll be gone against them.
Look, the record are there, Malad. Let me go through the record also.
Go through everything. We'll hear you to the complete, Mr. Payne.
Yes.
Friday. List on Friday on the prayer of Mr. J. Payne, Land Home Department, to enable the Home Department to file their affidavit in opposition, to raise any kind of objection that the department intends to raise. This order is necessitated in as much as objections are raised in course of the dictation of the order after completion of the hearing. Accordingly, hearing deferred till
Item 39 for hearing.
in other matter, tell Mr. Payne, we'll pass a comprehensive order.
Not,
We'll try to lay down the entire procedure. Otherwise, it's neither here nor there.
not.
Ask them to whatever you want to submit. Let him know. Yes, 39.
Item 39.
None appears for the petitioner. List again. In the event of subsequent non-appearance, the appropriate order shall follow.
Item 40.
In the morning,
Yes, sir.
it was mentioned, Lord, but it was not allowed, Lord.
At 10:30, a mention was made, which was declined. Mention for adjournment, which was declined. When the matter is called, none appears. List again. In the event of subsequent non-appearance, appropriate order shall follow. Anyway, Seneki, maybe people are not aware that item 39 will be called. Normally we do it, but maybe somebody is thinking that 39 is too far away. Next one, call the next one. Really, I will reconsider it if somebody comes.
41. Item 41.
41, same order. No. Because we call 39, excluding the category. So somebody may be thinking that my number is too far away. I'll come a little later. But
42.
Lordship, a small correction is.
no,
needed,
if
Lordship.
he doesn't come, why are you bothered?
No, Lordship. At the last order, the name of the school is wrongly typed.
Okay. What should be the correct name?
It is Polaguri.
In the order dated 21/6/2023, the name of the school is to be read as
Polaguri.
Kolakuri.
Polah, Lordship. POLAH, Polah.
It would not be lower,
Polaguri.
as Kolaguri Primary School. and not
Paharguri.
number 1 Paharguri Primary School. The order be read as corrected.
Lordship.
And the Education Department would do the needful by taking note of the corrected name of the school.
Lordship.
Next.
43.
Yes, please.
Page 16,
16.
Antovan Mesa is the mother.
16.
16.
Who is the mother? Santovan Nessa. She is the mother.
Mother and already examined. DW2.
What happened to Jasimuddin?
Jasimuddin is the father.
What happened to him?
Died already.
He died. Which year he died?
2007.
2007. So where is the voters list of the mother and father after 2000 up to 2007?
Lord, can you see page 22?
2079. Same village. Mohali year.
Jasimuddin is the father, my lord.
Just a minute. Year. (22) Jasimuddin and Sanjivan.
San Mystery is the petitioner.
San Mystery petitioner, 89.
Santovan Mesa is the mother.
Santivanu is the mother.
Mother, my lord.
Yes, what do you say? Mr. Sharma?
Lordship.
Let me go back. It's a one same list of the same village. The village is same.
Yes.
Third, Mr.
M.
M. Hawk, no? The petitioner, Chan Mahmud, alias Chan Mia, alias Chan Mystery, had been referred to the Foreigners Tribunal number
4 Golpara.
4 Gwalpara for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number FT bracket G4256/15. Tribunal rendered an opinion dated 28/2/2018, declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Bangaljor,
Bangalore.
police station Lokhipur in the Gwalpara district, which contains the name of Santobhan Nesa, wife of Jasimuddin Sheikh at serial 338, and that of Jasimuddin Sheikh, wife of Jasimuddin Sheikh, son of Ahadullah Sheikh at serial 340. It is claimed that Sandovan Nesa is the mother and Jasimuddin Sheikh is the father of the petitioner. The name of Jasimuddin and Sandivan Nesa also appears in the voters list of only Jasimuddin Sheikh appears in the voters list of 1970 of village Mangaljar. In the voters list of 1979 of village Mangaljar, the name of Jasimuddin appears at serial 257 and that of Sandivan Nesa at serial 258. The voters list of 1989 of village Mangaljar contains the name of Jasimuddin, son of Bahadullah at 545, Chan Mystery, son of Jasimuddin at 546, and Sandivanu Nesa, wife of Jahimuddin at 547. Sandivanu had also made a deposition.
Yes.
Sandivanu Nesa had also deposed before the tribunal as DW 2, stating that Chan Mystery is her son. In view of the above, remanded back to the tribunal to consider to examine the voters list of 1966, 1970, 1977, and 1989 of village Bangaljar, as well as the evidence of DW2 and pass a reasoned order thereon. The Home Department may make their verification and submit a report before the tribunal and also cross-examine DW2 if so advised. Upon being the needful reasoned order be passed.
Item 44.
Yes, Mr. Sarkar.
To kindly see the last order dated 3/4/24.
3-4. Some report, you have it?
हेलो यस हाँ हाँ कहाँ पे है आप नाहरलगुन
বন্ধ করে দিক তাহলে regarding the shifting, Mr. Sharma,
Yes,
regarding the shifting, what is
no
the
comment, Lord.
Hmm?
Regarding shifting.
No, where is the report in the inquiry regarding shifting?
That was not mentioned, Doctor.
That is the
Yes, Doctor.
inquiry that was ordered.
Yes, Doctor.
No finding on that.
Yes, Doctor.
Which one is yes?
No
No.
finding is there, Doctor, regarding shifting. Doctor.
By the order dated 3/4/2023, the Superintendent of Police Border Dhubri and Superintendent of Police Border Kamrup M was directed to make an inquiry and submit a report on the claim of the petitioner that Jamiran Bibi, whose name appeared in the voters list of 1977 of village Bogulamari, had shifted to village Chautara in order to enable her name to appear in the voters list of 1997 of village Chautara. A report of the superintendents of police border had been produced before the court, but the query upon which the inquiry was ordered is not answered in the report. Both the superintendents may file a modified inquiry report containing the answer to the query raised above. The report submitted before the court is returned back to Mr. G. Sharma. Yes,
Item 45 for admission.
Lordship may kindly pass over the matter for the time being. Mr. AR, we are here at the court, but he is on lag at another court. Lordship.
That's your lordship with this.
You have to wait for the whole day
Lordship.
because we have some other matters. Once we start with them, those other matters may take some time.
Lordship.
Mhm.
I have deposited this record lordship.
It will. No, matter to yes.
Illegal detention.
Detention.
Later.
Obliged.
6.
That taken to custody on 4/6 and their standing is on
Yes,
6/6.
6/6.
Okay. Item 46, who is appearing? None appeals for a petition of the matter is called list again in the event of subsequent non-appearance, appropriate order shall follow. পিছত মাতি লাগে করে যদি পিছত মাতি তেতিয়াহ'লে নন এপিয়াৰ্ছ কাটি দিব
Item 1 for motion.
Mr. Nair, we require your presence.
Lordship, I'm here.
Who's appearing for the petitioner?
But they are online, I suppose.
Join for a night.
Done করবো দিও।
I said it. Tony party no more.
এখন তুমি আকৌ স্ক্ৰীনখন ইফালে ক'ৰবাত দিব নোৱাৰি नाही वजन पाहिजे. बेलेग এখন দিব নেকি? All the time you can't looking to the right. নহয় আপোনাৰ ডিলিভাৰী হ'ব অলপ পিছত যিখিনি আৰু মানুহটো নোচোৱাকেতো শুনিব থাকিব নোৱাৰে.
আহিছে অলপ
Yes.
Mr. Tara is there.
Tara, you
Tara.
are there. Mr. Patin is there. I can see.
Patin
you.
is there.
I have joined my lords.
Yes, please.
Am I audible, my lord?
Yeah, very much.
This writ petition is directed against the repeated orders, administrative orders of the registry of principal seat, transferring the cases from the High Court of Arunachal Pradesh to the principal seat. My lord,
Can you look at any one of the administrative orders?
yes.
Page 34.
34 man, structure.
Yes. My lord, this is completely on the administrative side. No, this is not a judicial order.
No, which any of the impugn order, can I take a look at it?
34.
আমার মাত্র জানা নাই maybe.
Repetition of case, records of the case number, such and such and such.
He is 34 man.
Referring to
Mr. Patin, are we audible to you?
yes, audible, my lord.
Can we go through one of the impugn orders? Which page?
Yes, my lord, at page 34. This is the first order.
34.
34.
Okay, 34.
My lord, this was actually NSPC had filed a case in the principal seat, only indicating the district as Dhemaji, whereas in the petition, neither the state of Assam was a party, and there was no averments against any officer of the state of Assam. And if lordship will
No,
go through
just
the
a minute, Mr. Patin, go a little slow.
madam.
Requisition of case records of WBC 206, Jumgi Buchi versus NHPC and so Bomjen Hale versus NHPC.
Yes, my lord.
To inform you that the Chief Justice by the order has been pleased to allow transfer of the above mentioned writ petition to the principal seat. So very well.
My lord, this
So now, in what manner this order is unsustainable in law?
my lord, thereafter, we have filed number of cases in the state of Arunachal Pradesh. This is completely the cause of action wholly occurred in the state of Arunachal Pradesh. So now with these other impugn orders, around 86 cases has been transferred from Itanagar to Guwahati. Now we are having problems, my lord. My lord, you lordship will see these petitioners are all village people. They are not in a position to engage any lawyer also. So, and all this, the state of Assam.
Mr. Patin,
Yes, my lord.
the manner in which you are appearing before the court today, same manner can also be adopted when those petitioners appear.
My lord, this thing is my
Today you
resolution.
are appearing in a virtual mode. If
Yes.
your only difficulty is engaging a lawyer in Guwahati or coming to Guwahati, you can very much conduct your matter from Itanagar in the same manner you are doing it today.
But then, my lord, is still, my lord, there was a division bench. This division bench, honorable, our
Mr.
own.
Patil, tell us where is the illegality in this order? So
Well,
that we
the
can.
first is, these decisions to transfer was completely unilateral. The petitioners were not informed at all. None of the petitioners were informed. No notice. And it is not by the court.
Mr. Patil,
Yes, my lord.
today you must have had some matter listed before of yours listed in Itanagar.
Yes.
Some matter was listed, I think, when
Yes,
you
ma'am.
appeared at the council.
Yes,
Did the
ma'am.
Chief Justice inform you beforehand that your matter will be listed?
No, my lord. This is not.
Was your consent taken? Mr. Patil, I want to list your matter in today's list.
No, my lord.
There also it was not taken. Then why did you appear in the matter? You could have raised that objection that my permission was not taken.
My lord, my intention of
Where is the,
submission.
in other words, Mr. Patil, where is the requirement under the law?
No, my lord, my submission, intention of my submission is that there is this decision to transfer on administrative side. It is not based on any notice. We were not informed. It is.
No, where is the requirement?
Yes, my lord. My submission is, my lord, if we see the notification of creation of the Itanagar Bank.
Page number?
Guwahati High Court rules to 369. My lord will have page 316, 369, or 349, sorry.
I think by mistake I may not have annexed that notification, but I have made a submission, my lord, in my writ petition.
Mr. Patil,
Yes, my lord.
this book, Guwahati High Court Rules 2022, if you have it with you, it's at page 349.
349.
It's at page 349. If you have this book with you.
Yes, yes. Yes, 349. My lord, my responsible submission is that if we go to this paragraph 2, there shall be established a permanent bench of the Guwahati High Court at Arunachal at Itanagar, and such judges of the Guwahati High Court being not less than one in number, as the Chief Justice of that High Court may, from time to time, nominate, shall sit at Itanagar in order to exercise the jurisdiction and powers of the time being vested in the Guwahati High Court in respect of the cases arising in the state of Arunachal Pradesh. Number, the entire course of action occurred within the state of Arunachal Pradesh. So therefore, my lord, when this bench is sitting here, my lord, every day there is a division bench, every day there is a single benches are functioning, and state of Assam is not at all a party in this proceedings.
Mr. Patil,
My lord.
in that section 2, clause 2 of that order of 2000,
Proviso.
not proviso, just before the proviso,
Yes, my lord.
to exercise the jurisdiction and powers for the time being vested in the Guwahati High Court in respect of cases arising in the state of Arunachal Pradesh.
Yes, my lord.
Can you read one word, all cases?
My lord, there has been instances where cases
is the word all also available, that all cases arising in Arunachal Pradesh?
My lord,
So that
in
jurisdiction of any other bench is totally excluded. Can you read that word all?
my lord, if we read this word, in respect of cases arising in Eastern Arunachal Pradesh,
Is.
my respectful submission
But
would be,
it
it will include all the cases.
Where do you draw that presumption?
My lord, we have to deem it all in respect of cases arising in the state of Arunachal Pradesh. That means it will.
So, Mr.
cases.
Pertin,
My lord,
suppose we accept your contention when we pass a judgment today in your favor.
yes.
Tomorrow, some occasion arises, you are required to move a petition in the principal bench. That will be ousted.
No, my
You
lord.
go to the Chief Justice seeking permission that for this cause I want to move the petition in Guwahati. It will be rejected straight away by citing our judgment.
Normally,
Based on
my
this
lord,
statement, Mr. Pertin,
normally, my lord,
are you ready to face that situation?
no, my lord, when the petition, High Court in the UPI is functioning, my respectful submission that
We understand.
if we read this language being vested in the Guwahati High Court in respect of cases arising in the state of Arunachal Pradesh, my lord,
Where is
at
the
present,
outcome?
principal seat is functioning as the High Court of Assam, state of Assam, not the state of Arunachal Pradesh. Administratively, yes, everything is under the principal seat, but as of today, when the High Court is functioning in the Arunachal Pradesh, principal seat exclusively functions as a High Court of Assam. And as a High Court of Assam, when the state of Assam is not the party, not a single officials of the state of Assam is a party, but the principal seat at this stage may not have jurisdiction.
Mr. Pertin,
Yes, Malan.
inclusive of jurisdiction, we understand cases related to Arunachal Pradesh. But where is the exclusion of jurisdiction? Where do you read the exclusion of jurisdiction? What you submitted is the inclusion of jurisdiction. Inclusion,
Your Lordship may
yes.
kindly come
Where is the
to
exclusion?
Your Lordship may kindly come to paragraph 5 of my petition, page 8. My Lord, I have quoted the order of the division bench of our own High Court. May I read the entire paragraph, my Lord?
No, let us read the whole judgment. Asin,
2005 3 GFT 1.
2000.
It's the book. It's the I've given.
I have extracted that.
No, let us read the whole judgment.
2005 3 GLT 1.
Hindustan Paper Corporation versus Energy Composers.
I'll just read the paragraph 5, my Lord, and this thing. That the proviso to paragraph 2 of the notification dated 18/7/2000, which reads, provided that the Chief Justice of the High Court may, in his discretion, order that any case or class of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati. Explaining the legal
paragraph 5.
Yes, paragraph
Your-
5 at page 8, my Lord. Of my petition, my Lord.
Not your paragraph 5. What is the paragraph in the judgment?
37.
30.
It's 37. Well, this was by the division bench while sitting at the Shillong bench. Shillong bench. Referring to the proviso to paragraph 2, my Lord, I'm reading the.
Yes, please.
No,
Please,
my Lord,
read.
whether this transfer of cases is to be done according to as per the judicial order or administrative order is provided in the paragraph 39 of the judgment. But I have extracted at mail and lordship. Take your lordship to page 13 of my petition.
For the courts, Mr. Pertin, we are relying on the original judgment. You can
Yes, my
refer
lord.
to the paragraphs in the judgment.
Yes, my lord. 39, paragraph 39, last last nine lines, my lord, of the paragraph 39. The question as to whether, my lord, your lordship got it. The question as to whether the case has legally arisen within the state of Meghalaya is a question which has to be answered judicially and cannot be decided
Where are you?
administratively by the Chief Justice.
Which
My lord, it has
paragraph of the
slightly
judgment?
different connotations, but then, my lord, whether a case has to be transferred or
Mr.
not,
13, which paragraph of the judgment you are reading?
paragraph 39.
39 begins with what surfaces?
Yes. My lord, from paragraph 39, last portion,
Okay,
last line
portion.
from nine lines.
The question as to whether the case has legally arisen within the state of Meghalaya.
Yes,
is the
right.
question.
Yes.
Yeah.
Has to be answered judicially and cannot be decided administratively by the Chief Justice. Hence, it is the judges or the judges hearing the matter who will have the power to determine as to whether a case has arisen within the state of Meghalaya or not in order to attract the jurisdiction of a bench of the Common High Court. My lord, it has a slightly different connotations, but then, my lord, my respectful submission is that the principle here enumerated is it is the court who will decide whether it can be transferred or not. The Honorable Chief Justice on the administrative side cannot just decide to transfer the case, and that also without issuing any notice, without letting the petitioners know whether they are agreeable to or not.
Where is the requirement of issuing notice, Mr. 13?
My lord,
Where is
at least
the question of natural
the
justice
me
coming
as
in
a
the listing
petitioner.
of a matter?
No, my lord. My responsible submission, my lord,
Mr.
it cannot be. It
Mr.
cannot be unilateral.
Mr. Pertin, what you are submitting has to be read in the context of all cases being listed in the Guwahati High Court. It cannot be read differently for listing of one matter and read in another manner for listing of other matters. So tomorrow, if you have to accept your submission, for tomorrow, every matter being listed, the registry will first have to issue notice to the petitioner, where it will be listed. That requirement.
My submission
So,
is
if in general it is not there,
not judicially.
in your case, how can it be brought in?
No, my lord,
If
it is
in
not a
general that
judicial order.
requirement is not there, for this case, how that requirement can be brought in?
My lord, is that my lord, in this, if this is allowed, there will be total chaos. Now, my lord,
By allowing
people
a
are
petition,
doubting.
it will be chaos.
NSPC, my lord, the conduct of NSPC has to be looked into. Right from the beginning, this is almost 20 years.
We are not,
Yeah,
Mr. Pertin, we are not on NHPC. We are on only one legal question that has been raised in this petition, that the Chief Justice, when he lists the matter of Arunachal Pradesh in the principal seat, firstly, your submission, he has no jurisdiction. Secondly, your submission is the litigant has to be notified and taken their approval taken where is to be listed. Where is that provision of law? It can be either one way, that there is a general perception that before every listing, the High Court will inquire with the litigant where you want your case to be listed, or generally it is not required, but specially for your case it is required. There is neither the general law nor there is a special law. It is only your desire.
No, my lord. My responsible submission. See, my lord, when the Chief Justice has decided to transfer a case, my lord, the Honorable Chief Justice also cannot act unilaterally without letting anybody know. Maybe it was people are doubting.
So you are again back to the same question. Yours is item number 1 today.
Yes,
So before listing the matter, Chief Justice ought to have taken your approval. Item number 2, I think somebody else appearing. Before listing that, Chief Justice has to take the approval. Should I list the matter in as item number 2 in today's list?
my lord, that my lord, listing in the court and transferring unilaterally, I think.
Transferring is a part and
Two
parcel of the list.
issues, my lord.
It's a
We are
part and
concerned
parcel
about
of the
the unilateral transfer of the cases on administrative side.
Where is that requirement of law, Mr. Pertin?
My lord,
Please point out
the
so that we
order-
can hear you.
My lord, there is also no order enabling the Chief Justice to unilaterally transfer the cases on administrative sites. This proviso cannot defeat the main object of the paragraph 2 of the
So your
notification.
legal argument is proviso to clause 2 cannot defeat the
Main intent of the paragraph
main
2.
enactment of clause 2. Okay, we
Yes,
take
ma'am.
note of your
Yes,
argument.
ma'am.
Very well. Now, where does clause 2 provide that every matter of Arunachal has to be in Itanagar?
My lord, though
That
the
is
word
not there.
all are not there in the language, but if we see, shall see that Itanagar, in order to exercise the jurisdiction and powers for the time being vested in the Guwahati High Court, in respect of cases arising in the state of Arunachal Pradesh. Cases arising in the state of Arunachal means all the cases.
So, under which
And-
interpretation of law?
Any transfer.
Mr. Pertin, we are understand your anxiety, but which provision of interpretation of law can allow the court to add one word to a statute? Because to accept your submission, we have to add one word all before the expression cases. Which
But
interpretation
otherwise-
of law will allow the court to add a word?
Otherwise, my lord, my responsible, otherwise, how can this in respect of cases arising can be interpreted to limit the power of the court? It also does not say that the Chief Justice can do anything. So my responsible submission is, my lord, the law has to be interpreted in a wider perspective, the main intent of the law. So in respect of cases arising, my lord, This-
Now, Mr. Pertin, you rely on that judgment in that Hindustan Paper Corporation.
my lord,
Are you aware of the factual background of that matter?
my lord,
Are you
some
aware?
case-
Did you
Uh,
read the whole of the
partly, my lord.
judgment? Sorry,
partly,
you
but,
have extracted one sentence to substantiate your argument, but have you gone through the whole judgment? In what circumstance it was passed?
my lord,
Mr.
actually,
Pertin,
government had no jurisdiction.
that judgment was passed on a premises where one of the litigants had made a prayer that this petition be shifted to the
Shillong.
principal bench.
Yes.
So
No, my lord, but
there question arose whether a litigant can make an application. There the court held that in that circumstance, it is not the Chief Justice, but it is the bench concerned which will decide. But the Chief Justice is the master of the role.
my lord. But then,
Where a matter in which
role
court
can-
will be listed, the Chief Justice is the master. That is
I
the
agree, my
general
lord.
power of
I
the
agree,
Chief
my-
Justice.
Yes, I agree, my lord.
So,
But then, my lord, does
Guwahati
it
High
mean that-
Court, Mr. Pertin, please listen to the whole of the question. Guwahati High Court has, I think, Mr. Nair, how many number of courts? 19, I think, presently functioning. 19 number of courts in the principal bench. In addition to that, Guwahati High Court is having 2 further courts in Itanagar bench, 2 further courts in Aizawl bench, and 2 further courts in Kohima bench. all these courts are courts of under the Guwahati High Court, of the Guwahati High Court, in fact.
Correct.
Once it is it not the Chief Justice being the master of the role to decide in which court a matter will be listed? Can that power of the Chief Justice be taken away?
No, my lord. But then that power is a restricted power. My lord, that a method would be transferred to
Where is the
Mizoram.
power, where is the power and where is the restriction? Please submit. Please
Well,
show us the restriction from where you derive the restriction.
If this power amounts to shifting and transferring of the jurisdiction, then in that case, my lord,
No jurisdiction. It is a part of the one court.
my lord, it is like shifting the jurisdiction. The power of
jurisdiction.
the Arunachal High Court is being shifted, taken away.
I think your expression maybe in future it may be right, but present it may not be. It's not a high court of Arunachal.
No, my lord,
In future it may be.
My lord, may I interject for a moment?
Yes, please, Mr. Tara.
There is no quarrel that Chief Justice is the master of the roster. That my lord will find at page 349 of 2022 rules in the proviso with reads, provided that the Chief Justice of that High Court may in his discretion order that any case or class of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati, my lord. So the proposition is clear now that Chief Justice, Honorable Chief Justice is the master of the roster, and the notification itself has provided the power to the Honorable Chief Justice. Now, in the meantime, what it requires to read is, my lord, notification order number 41. My lord will note down. Order number 41.
Page number?
No,
Where
it
do
is
you-
not there. It is an order by the Honorable Guwahati High Court. Order number 41 dated 26/10/2005, my lord.
Where do I get that order?
My lord, it is not available.
No, I'm not having it.
My lord will kindly call from the registry wherein it says, if the benches in Itanagar is sitting, then all the cases should be transferred to Arunachal bench, my lord, Itanagar bench. My lord will kindly call for that notification.
Dated.
Dated 26/10/2005. Order number 41, sir. My lord will kindly call for, and we can come back at 2, my lord, lunchtime.
Okay. So your submission is by virtue of that notification, every Arunachal matter has to be in Arunachal.
Yes, my lord.
Okay, will read.
Pleasure, my lord.
And
We'll come back.
Mr. Pertin, before that, you'll have to also give one more answer.
Yes, my lord.
I think this person is having some pending litigation, some other pending litigation.
The petitioner. Yes, he has filed a petition. His case also has been transferred to Guwahati.
No, maybe this petitioner Tari High.
Yes, my
some
lord.
other writ petition of his is pending in the Itanagar bench, I think.
No, that has been transferred to Guwahati. That is why we
has
have
been transferred, but otherwise it was pending in the Arunachal bench.
Yes, it was filed in Itanagar only.
It was pending. Now, if you are challenging the transfer, don't you think this is, in fact, directly a forum shopping that you want the matter to be heard in Itanagar and not in Guwahati? Had it been a public interest litigation or somebody absolutely unconnected with any pending litigation, we understand. Yes,
Yes, I will
issue
answer
has
to that.
come because of these notifications, whether Arunachal matter should be in Arunachal alone and nowhere else. Definitely we'll apply our mind. But in the context that this person has a pending litigation, is he not indulging in forum shopping in requiring That's my matter. We heard in only in Itanagar and nowhere else. Can you do it?
Yes, yes, my lord.
Okay, we'll rise for lunch. We'll come back to you.
All right, my lord.
Yes. Let's start.
My lord, that
My lord,
notification 26/10/2005, my lord.
Yeah,
May
we have
be brought on record first.
this one. We have this one.
Yes, my lord, grateful, my lord.
Yes, Mr. Patti, please continue. Please continue, start. Am I audible?
Yes, my lord.
Lord, am I audible?
Yes, Mr. Patti, please start.
My lord. My lord, I respectfully submit that the filing of this petition is not a forum shopping. But then, my lord, my only concern, my only concern is that this notification has created a territorial jurisdiction and has distinguished the area of which High Court will take up what cases. So, my lord, maybe with these impugned orders, it might appear to be order transferring or creating a territorial jurisdiction, not in conformity with the notification. My lord, this may not be taken as otherwise. But,
No, we are not taking. We are asking questions to enrich ourselves so that we can understand.
yes, my lord. So, my lord, since I do not have, I was searching for this 26/10/2005
No,
order.
no, this
My lord,
one
I
we
had
have
gone
it.
through this once.
Hmm.
So, my lord,
We have it
at
with
the initial
us. Where is
initial
Mr. Rai?
stage.
What is it?
Just for a moment, he has gone to court number 2, my lord. He, some matter, my lord, he's come, he will come, my lord.
See, if you come to page 349,
Yes, my lord.
that 349 of this book, High Court rules,
Yes, my lord. The notification, my lord.
that notification.
Yes, my lord.
In exercise of the power conferred on subsection 2, section 24 of the State of Arunachal Pradesh Act, that's the act by which the state was formed.
Yes, my lord.
Read with subsection 2 of section 31 of the Northeastern Areas Reorganization Act. Again, this act also provides for the state of Arunachal Pradesh.
Yes, my lord.
Under these two provisions, this rules order had been framed.
Yes.
Okay. What it says that called the Guwahati High Court establishment of a permanent bench at Itanagar order. So from by virtue of this order, the Guwahati High Court permanent bench at Itanagar
Yes.
is created.
Yes.
What will happen? There shall be established a permanent bench of the Guwahati High Court, Itanagar, and such judges of the High Court, being not less than one in number, shall sit at Itanagar in order to exercise the jurisdiction and powers of the time being vested in the Guwahati High Court in respect of cases arising out of Itanagar.
Yes.
So this is jurisdiction which is inclusive in nature,
Yes.
or it also excludes. It's a inclusion jurisdiction or exclusion jurisdiction.
It says, being not.
No, we have read it. You don't
Yes.
have to read it. We are just asking your interpretation.
Yes.
This is a inclusion jurisdiction or this is an exclusion jurisdiction.
My lord, by this clause.
Inclusion means what all are included. Exclusion means what all are ousted, excluded.
Lordship. My
So
lord,
this is inclusion jurisdiction or this is exclusion
to
jurisdiction?
my understanding, my lord, this is inclusion jurisdiction.
This is inclusion.
Exactly.
Moment it is inclusion jurisdiction, that means exclusion is also permissible?
Yes, my lord. And that's where the proviso comes into play.
Hmm.
Giving power to the Chief Justice, which is discretionary in nature. If the Chief Justice in exercise of his discretion, any case or class of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati. So the Honorable Chief Justice has been conferred with that power by virtue.
So one aspect will be power of the Chief Justice. Another
Correct.
aspect will be a discretion of the Chief Justice. If it is a power of the Chief Justice may exercise the power in any reasonable, acceptable manner. Okay. What is the difference between the power of a Chief Justice and discretion of the Chief Justice?
Not so far as the power of,
How do you distinguish the two?
Lord, in my respectful submission, the Chief Justice.
No, just,
Lordship,
and you are only confining yourself to this line. We are asking you in general.
Lordship,
Okay, then take out the word Chief Justice also.
my lord.
Say one authority X.
Yes,
Power of the authority X and discretion of the authority X. Is there any difference or it is one and the same?
my lord, both has to be read together, my lord. Power,
We are asking you, is there any, is it one and the same or there is a difference between the two?
my lord, in my respectful submission, my lord, it's one and the same.
It is one and the same.
Yes, my lord.
So a power of an authority and the discretion of an authority, according to you, it is one and the same.
My lord,
Think
power-
about it. Because depending on the answer, we're going to ask you the next question.
My lord, to my understanding, power is, my lord, the discretion is the consequential
See.
act of the conferment of power.
What is the basis of this argument?
My lord, if we go by the proviso,
Please think.
my lord,
Think a little deeper and then make your submission.
my
Don't just instantly react.
lordship,
Power of an authority and discretion of an authority. Is it one and the same, exactly the same level, or the two concepts are at variance with each other to be looked into from two different perspectives?
lord. In my submission, my lord, discretion is perhaps one step ahead of the power given.
Discretion is one step ahead of the power, or discretion is one step short of the power?
Power, my lord, power has been conferred, and after conferment of that power, in exercise of that power, my lord, he has to.
No, we are, you are on totally
I
different.
perhaps, my
you
lord,
are
I have
on
failed
totally
to
different.
understand the question of your lordship.
Question is very simple. And there is an authority X.
Yes,
Authority has some certain powers
yes,
to do whatever those powers require them to do. The authority also has a discretion to do something.
yes.
Is the power to do something and discretion to do something one and the same,
No,
or they are at a variance? That is what we are trying to
I'm
ask.
sorry, my lord, at first instance, my lord, I just failed to, my lord, understand your lordship's query. My lord, power and discretion, absolutely different thing, my lord.
Yeah, different. Now come to it. So what is power and what is discretion?
Power is to act in a particular manner. That is the, if we consider here, my lord, the X, the authority, here, he is the master of the roster, my lord. Since your lordships also mentioned,
previous.
No, he is the master of the roster.
He is the master of the roster. He can allocate benches,
Yeah, where do you get it? He is the master of the roster.
my lord.
Where is the proposition? If you're not ready, tell us. We'll defer it to for some other day.
I can, my lord, I'll just,
Because this is vital, because we are deciding that issue. Where is the proposition that Chief Justice is the master of the roster? And what exactly it means? Had it been within the same principal bench, it is okay.
true.
Whether matter will be before this court or that court, that's the power of the master of the rosters. But here, a separate bench had been created with a definite objective pursuant to certain statutory powers.
True.
You can construe it to be an extended form of the Guwahati High Court.
Yes.
True.
Yes.
To what extent?
Lord,
Is it an absolute extension? That is there any difference between this court number 6 sitting here and the bench sitting in Itanagar, or there's a difference?
it is an
See,
extended
it's a very
limb of the Guwahati
it's
High
a very
Court, but
delicate and sensitive issue you're dealing with,
yes, my lord, that's true.
and having a lot of implications.
Yes,
So just don't make your submissions means
No.
that the first thought that is coming to your mind.
lordship,
It will have its implications.
yes.
My lord, in between there is two words
Hmm.
where word shall and may has been used. Word shall occurring in
No,
the
it a word made in the proviso.
proviso.
Hmm.
May
May, definitely may.
may would mean that if any power is to be exercised, it must consider the circumvening situations so that litigations are
Just
not
wait,
faced.
Tara, we are in fact we're trying to come to that only. That's why you're
Sorry, my lord. I thought of bit of assisting my lords.
No, in fact, we are trying to reach that position only. What do you do? You can answer today, or because Mr. Pertin has made his case very clear. He relies on this order of 2000. This is the statutory order by which the Itanagar bench had been brought into its existence. It has been given certain jurisdictions. Now, his case is by virtue of these communications, the jurisdiction vested in the Itanagar bench had been taken out.
Correct, my lord, because
Whether, firstly, whether question is whether it can be done. Secondly, if it can be done, in what manner it is to be done. This is what we are required to examine.
Exactly.
And Mr. Tara also adds to his submission of Mr. Pertin that by this order of 2005, it also provides for certain.
You know, this.
for one reason, my lord, because that notification is statutory in nature and administrative decisions cannot override the statutory rules as framed under the Act, my lord. So there are two things, my lord.
This one is the administrative order.
Yes, no. By means of that administrative order, entire cases of Itanagar bench has been transferred to Guwahati principal bench, my lord. So meaning thereby,
This one is an administrative. The impugn order is an administrative order.
correct, my lord. Therefore,
And what about this order? That the 26/10/2006.
that is
This is an administrative order, or it is a statutory order, or
no,
it
my lord.
is
This is also that 26/10/2005 order is also an administrative order, my lord. Now the next question comes, my lord, whether administrative orders can override.
Oh, that is a proposition we understand. Statutory provisions cannot be overruled by administrative, but that proposition we understand.
So
But
therefore,
before we go to that proposition, let us find out what are all these. Yes,
Nair
Mr.
sir, yes, Nair sir.
What we are asking is, what is the difference between a power vested in a particular authority and a discretion vested in a particular
My lord,
authority?
we'll have that
How do you
340
distinguish the
My
power
lord,
and the
we'll have
discretion?
349.
Yeah, we have
page
read it.
No, my lord has read it. It gives the power to exercise a discretion. But if I may just put it in that manner, my lord. What it does is that it
We
says-
are asking you conceptually a power on an authority and the power vested on an authority and the discretion vested on an authority, whether it is one and the same concept or it is at a variance.
It will be at a variance.
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 Once power and discretion is at a variance, how a power is to be exercised and how a discretion is to be exercised.
My lord, in a given situation, I am given the power to act in a to take certain decisions in a particular manner. And in a different situation, I'm given a discretion that this is what is happening. But if I find, my lord, that some other decision is to be taken in the matter, I'll exercise.
No,
my-
what I'm asking is, one concept is a power being vested on an authority. Okay. Suppose a power is vested on my court master that he can give 100 rupees to all the lawyers who come to the court. Okay. He can give it because that's a statutory power he is having. He is exercising it. He is giving. The moment you come in, one man will be there. He'll be. A discretion is vested in a court master.
He can take a call.
To give 100 rupees to the lawyers to come in. What will be the manner of exercising the two different powers?
My
Will
lord,
it
when
be
it-
one and the same or it will be
My
different?
lord, when it will be the power that without any, my lord, limitation, he can exercise. But when it is a discretion, there has to be certain elements.
This is
therein.
exactly the answer we are trying to extract from you.
That's it, my lord.
Now,
There has to be certain elements.
so now,
And one thing, my lord, that certain elements may be disclosed or may not be disclosed. I'm coming to one aspect of the matter. May be disclosed, may not be disclosed. Therein, my lord would have to exercise a slightly more inquisitive role or slightly higher role to see whether that discretion can at all be exercised by an authority specified. If that discretion can be exercised by that authority specified, and there is no allegation of any mala fide, if I may come to that, mala fide, then my lord will not go and question that, subject to what my lord would finally say. Now, the decisions that are there before my lord, the decision of this honorable court in that Shillong matter, what had happened there and what my friends are trying to.
no, that is
No,
not
there is one catch there, madam. There is a catch subject to what I've understood, because I just could go through it in the morning, madam. Therein, a writ was filed in the Shillong High Court. And that writ was filed there without there being a cause of action arising in the state of Meghalaya. Now that matter was to be transferred to Guwahati. The issue was, if that writ could not have been filed in Meghalaya, it could not have been transferred also. That's my lord para 39. If my lord, my friend had read the bottom portion, if my lord reads the whole paragraph.
Understood. So
Then the court
if
says,
the writ itself could not have been filed,
then it could not have been
it
transferred.
could not have been
Then the
transferred.
court says, if the writ was maintainable in Meghalaya, it could have been transferred. And this is the same thing relying on a Supreme Court judgment of 2001 of Rajasthan. Jodhpur and Jaipur. My lord, Jodhpur and Jaipur were given two different benches were set up. This is, my lord, within the High Court only. 2262 will not, 1 and 2 will not come in. Because this is within the High Court, my lord.
226.
1 and 2. Asana? My lord would. My lord, this is the powers. Two, my lord. The powers conferred by section 1 to orders.
You are reading what you are reading?
2262, my lord.
226(2).
2.
Constitution. Why are you reading
I'm just showing, my lord, that this will not come in here because this is within the High Court only. My lord may ignore that, my lord. Now, what I was trying to emphasize before my lord is, there is another notification which has been placed before my lord by Mr. Tara. Or that notification number 41. If my lord reads it further, I think it's in connoissance with this matter. Every case has to be filed and done in Arunachal. It says all cases which are pending here.
So we read it.
And my lord, which will be filed in future, will go back. That in no manner inundates or dilutes the power under this proviso, my lord. This proviso power is overall there, and the Chief Justice in a given, it's not that, my lord, all the cases from Arunachal have been brought and being done here. Selected matters, which will, under the discretion of the Chief Justice, maybe he has some inputs, because this prayer was dealt with 3 Chief Justices, my lord. That's my instruction. It was
Yes,
rejected. This prayer, my lord, for getting those matters back. 3 Chief Justices have dealt with it, and all the 3 Chief Justices have held that no, these matters. First, my lord, one matter came here. Then there was an application filed that this matter should be posted back there because there are similar matters pending. Honorable Chief Justice said, nothing doing, get those matters here.
And instead of sending this one, get the other
those matters here. That's how, my lord, it has come here. And then this immediate, there was a prayer, and that was also.
No.
My lord Justice Dulia, I think, was
Mr. Nair.
lordship.
Just because factually it happened that 3 successive Chief Justices had taken the same view will not give enhanced legality to the view.
What I'm trying to say is, my lord, even the Supreme Court has said that every matter in that Jodhpur and Jaipur, it will be held in Jodhpur and Jaipur subject to the power of the Chief Justice under that proviso there. Therein also the same proviso was there, my lord. And this honorable court in para 39 also said, division bench also said.
Jodhpur and Jaipur are within the same state.
Same state.
Number one.
And we have that interpreted.
And there the benches must have been created out of some administrative arrangement.
No, it was created by the president, my lord.
By
The division by the president.
Maybe by the president.
Lordship.
But it's within the same state.
Fine. And here
it comes
from Arunachal.
The
we have the
Arunachal
Meghalaya
bench
matter.
had been constituted pursuant to subsection 2, section 24 of the Arunachal Pradesh Act.
And here
it's a
no, my lord. It is under the section 31 of the in powers of so and so of the state act and section 31 of the Northeast Eastern Areas Reorganization.
Section 31(2) of the Northeastern Reorganization Act 71
Lordship.
provides for reorganization of the Northeastern region. That is also related to creation of the state of Arunachal Pradesh.
Lordship.
And state of Arunachal Pradesh Act 1986 also pertains to the creation of the state of Arunachal Pradesh.
Lordship.
So by this statutory provision,
Lordship.
a new state had been created.
Lordship.
And in that act, there is a section 24(2), state of Arunachal Pradesh Act. Some powers had been conferred that a permanent bench will be created in Itanagar.
Lordship.
So this order is under that section.
Fine. And the
So-
Meghalaya one also, so the same.
So maybe
Yeah, my lord, that's a
so the difference between Jodhpur and Jaipur
My
and
humble,
Guwahati and Itanagar,
my humble submission, my lord.
the legal implications, it may not be same.
Why I say so, my lord? If my lord would have that 2001 judgment,
Because take an example of Bombay High Court.
Hmm.
Bombay High Court benches in Aurangabad and Nagpur,
lordship,
apart from Bombay.
lordship,
It also has a bench in Goa.
Goa.
Is the bench in Goa and the bench at Nagpur or Aurangabad of the same Bombay High Court at par, or there is a
my
difference?
lord, any
difference
matter which
between
comes up
the
within the state of Goa will go to Goa bench.
I understand. And any matter within the administrative
Territory.
area of Nagpur will go to Nagpur
Nagpur.
bench.
Rest
Aurangabad
will be with here.
we understand.
But
But
here, the-
Goa being a separate state, is there any fundamental difference between the Goa bench and the Nagpur bench?
my lord, there,
Or
would-
I count it is one and
my
the
lord,
same?
therein also this proviso will always be there.
You are giving a different answer. The legal aspect of the Goa bench and the Nagpur bench, it will be same or
It
different?
will be same.
Same.
Why I am saying so, my lord?
Why you
Nagpur
say?
bench is also created under a statute. Under some powers of given by a statute.
Under which statute? it
That,
is
my lord, I'll have to,
created?
I'll
Please
just
find
come
out
back to your lordship.
How Goa bench is created and how Nagpur bench.
I'll do it, but here, my lord, the Jaipur and my lord, Jodhpur thing, it's totally different, my lord. Both have different jurisdictions. Why I say so? In exercise of powers conferred under subsection
Definitely,
2,
it has to have.
so and so, after president, after consultation,
Mr. Nair, suppose today one Silchar bench is created.
fine.
It will have jurisdiction over
Lordship.
the Barak Valley area.
And my lord, the
And
case,
Barak Valley area matter cannot be brought to Guwahati.
good, no, it
Once
cannot be.
Silchar is there.
My lord,
But
the discretion,
a bench constituted pursuant to a statutory power creation of a different state. Pursuant to that statutory power, a bench is created. Its legal implication and a bench being created within the same state for administrative reasons. Will it be one and the same?
my lord, with regard to Shillong,
Not Shillong.
Meghalaya.
Arunachal Pradesh.
No,
Straight away I'm asking.
No, but I'm making a submission because Arunachal now, my lord, my lord will be laying down the thing. With Meghalaya, the same issue arises. This honorable court answered in this manner. Just, my lord, I'm not placing, I'll place it later. In that, my lord, para 39. 2005, 1 GL, 3 GLT, my lord.
I think we'll have to read the whole of this judgment.
Lordship.
One.
Oh, my lord,
line,
what's
one
that
paragraph
Bombay
correct
thing,
there.
Goa thing, my lord? I can get that also, my lord. So that my lord will have a complete picture of what is happening. Just, my lord, just read
Because
it.
why I am saying,
Lordship.
one is administrative convenience that within one state have two different benches because maybe of the volume of the matter.
Another one is because of this state. going
One
on.
is creation of a state, and the statute creating the state gives a statutory requirement of establishing a bench there, and after that what will happen?
Lordship. What surfaces from the above discussion as regards the scope of the proviso is that a proviso appended to para 2 of the notification, same proviso was there. Aforesaid merely craves out an exception to the main proviso to which it has been.
The principles.
When the language of the mean items so and so ambiguous, the proviso can have no repercussion on the interpretation of the mean. The proviso has to operate in the same field in which it has been in which the main enactment, that is para 2, operates. A careful reading of proviso to para 2 clearly reveals that the Chief Justice may, in his discretion, order that any case or classes of cases arising in the state of Meghalaya be heard at Guwahati. This in turn implies that the state Chief Justice can direct a case or class of cases to be heard in Guwahati, provided that the cases has legally and constitutionally arisen within the state of Meghalaya.
You are reading 39.
39.
What
surfaces from the above discussion is as regards the scope of a proviso is that proviso appended to para 2 of the notification aforementioned merely craves out an exception to the main proviso to which it has been enacted. When the language of the main enactment, that is para 2, is explicit and unambiguous, the proviso can have no repercussion on the interpretation of the main enactment. The proviso has to operate in the same field in which the main
Proviso
enactment
can have no repercussion on the
in interpretation of main end. The proviso has to operate in the same field in which the main enactment, that is para 2, operates. A careful reading of the proviso to para 2 clearly reveals that the Chief Justice may, in his discretion, order that any case or classes of cases arising in the state of Meghalaya be heard at Guwahati. This in turn implies that the Chief Justice can direct a case or classes of cases to be heard at Guwahati, provided that the case has legally and constitutionally arisen within the state of Meghalaya. If in a given case, no cause of action has arisen within the state of Meghalaya, para 2 of the notification will not be attractive. And consequently, the question of applying the proviso to para 2 or taking recourse to para 2 will not arise. To put it differently, if a case had not arisen in accordance with law within the state of Meghalaya, the permanent bench at Shillong will have no jurisdiction. And by taking recourse to the proviso to para 2 of the notification aforementioned, the Chief Justice cannot direct that the matter be heard at Guwahati. The power given to the Chief Justice under the said proviso will come into play only when a case has legally arisen within the state of Meghalaya. The question as to whether a case has legally arisen within the state of Meghalaya is a question which has to be answered judicially and cannot be decided administratively by this Chief Justice. Hence, it is the judge or the judges hearing the matter.
This question does not arise here.
Here it does
This
not arise.
question does not arise
Does not
here
arise.
because admittedly the entire cause of action
That's
is
first
in
thing.
Arunachal.
So, my lord, by reading this paragraph, if the power has arisen, the cause of action has arisen, the case has been legally registered in Arunachal, then the power under proviso will be exercisable by the Chief Justice and he can transfer the matter. That's the, my lord, what flows from para 39, according to me, my lord.
If the judgment is not applicable at all in this case, you cannot even extract one line 2 of this judgment.
No, what I'm
Because
saying,
this judgment holds something totally different. Entire legal formulations of this judgment is on the premises that the cause of action of that matter did not take place in the state of Meghalaya, as because of which no writ petitions could have been filed in the Meghalaya bench.
so the
So
prayer for
therefore, as the writ petition itself could not have been filed, there is no question of transferring the matter from Meghalaya to Guwahati, from Shillong to Guwahati. And whether cause of action had arisen in Meghalaya or not will be decided judicially by the bench taking up the matter there. This is all it provides.
But it also says, my lord, implies that the Chief Justice can direct a case or classes of cases to be.
But this is a for that judgment, that's an obiter. It's not a ratio.
Well, whatever your lordship would say, I'm nothing, I'm just placing it. My lord says that no matters can be of Meghalaya.
No, we are not saying
but
anything.
I'm-
We are
and
hearing
that is my submission, my lord. Say, my lord, tomorrow a decision is made that no matter of
We
Arunachal
are saying,
or any other
all
benches.
that we are saying, that this judgment is not relevant for this purpose.
Fine, my lord. My lord will
Mr.
forget it.
Pertin had relied upon it, a given
My lord will-
sentence.
my lord will ignore that.
You have demolished
My lord,
his
let's only
submission
stick to
saying
the-
that it is
let's
not
only stick to
applicable.
the proviso, my lord.
So now let
The
us,
proviso has to be given a meaning.
now let us understand the proviso.
My lord will have to give a meaning to this proviso.
Before that, let us read 24(2). Under what power it had been framed.
My lord, I, no. Lordship would do one thing, my lord. If my
Malad,
lord can have
in
it-
fact, in this paragraph which Mr. Nair has read, it is clearly provided that Malad, if in a given case, no cause of action has arisen within the state of Meghalaya, paragraph 2 of the notification will not be attracted, and consequently, the question of applying the proviso to paragraph
This
2
issue
or
to
taking
decide, my lord,
recourse
I'll
to
have
paragraph
serious-
2 will not arise at all. Malad, my case is the entire cause of action has arisen within the state of Arunachal Pradesh. So therefore,
we-
my lord,
we
make
already
a mistake.
taken note
I've
of
just
that.
got the matter. Let me also formulate. Give me some time. My lord, the issue here is, my lord. My lord,
No, here ultimately.
No, my lord will have to take a call.
See, it's a serious
Yes.
issue that has been raised.
Yes. It's a very serious
You
issue.
just can't take a view either this way or that way without
That's it.
giving a due consideration to the
That's
matter.
it. my lord. Neither my lord can say this way or the other
When
way.
Mr. Pertin is submitting, we have raised some questions to
Lordship,
him,
my lord,
and when
we-
Mr. Nair is submitting, we are
We'll
raising
have
certain
to. My
questions to
lord, we'll
Mr.
have
Nair.
to. So what I propose is, my lord,
So
let me also arm myself with
putting
something.
question to Mr. Pertin doesn't mean we are against
No,
Mr.
no,
Pertin,
no,
and putting question to Mr. Nair doesn't mean we are against
My
Mr.
lord,
Nair.
I'm obliged that now I know where I have to go. my
So
lord.
we are putting the question so that you
The
can,
answer comes, my
you
lord. I
can
know where
open
I have
up
to go.
the deliberation.
My limited prayer before my lord is today morning, my lord, I was, my lord, given all this. If your lordship can have it,
Definitely.
but only thing, my lord, what I want to bring, I'm not taking, what I want to bring, my lord gave an example of Goa. Goa and
Look at
Bombay.
that also.
Goa. So I'll try to get those notifications.
Why
whether
Goa we have given,
Lordship,
Goa will be a
Example.
example in one go.
lordship.
You are
And I
giving the
remember-
example of Jodhpur and Jaipur. We are dealing with
Arunachal
Assam and
and
Arunachal.
that would be
So,
appropriate.
in one go, the answer will be there because Bombay has benches in Nagpur and Aurangabad for the state of Maharashtra. Bombay also has bench at Goa for the state of Goa.
Goa. It's a high court
So
of
therefore,
Goa and Bombay.
I brought in the example of
Because,
Bombay.
my lord,
High
if
Court.
I'm not sure whether I can find it, but there was an incident somewhere I read, some cases, my lord, I think that that football academy, my lord, Ribeiro, famous, my lord, Ribeiro, those cases, my lord, were transferred. There was something, my lord, I don't know. I'll check up, my lord.
In Bombay High Court, it was done.
It was brought to Bombay High Court. My lord, there were some allegations there against him. Cases were filed, but that was not taken in Goa. It came to, my lord, Bombay High Court, and the matter was finally decided in the Bombay High Court. Long back, my lord.
No. Sometimes matters can be of such also that a given place is the place where the jurisdiction lies to proceed in a given matter. But the circumstances are such that it is not conducive to hold the proceeding in that one.
Place, then you can.
So although you don't have the jurisdiction, you bring it to a place of another jurisdiction and hold it. Say, for example, those that mob lynching in Karbi Anglang, that trial. Division bench has passed an order, trial we held in Nagaon.
My lord, I'll
There
go a step further.
There
That
are
case of, my lord, the chief minister, my lord, famous chief minister, Arunachal.
In fact, Malad, some criminal cases of Arunachal is taken up by in the Lakhimpur court.
It's there. These are separate issues.
But my lord, the master of the roster is the chief justice. And that discretion which is given.
That question we already put.
My lord, will have it on a convenient date, my lord. Give me 2-3 days time. I'll try to get an answer.
But considering the statutory impact of the Arunachal Pradesh Act.
I'll have to go through that now. 24-2.
To what extent will be the concept of master of roster be applicable?
It will be very big loss for us if my lord goes up. No cases can be found yet.
My lord, Nair sir is afraid of that Navin Chandra Majatia judgment.
Just, I can do that. Tell that. That's why.
And maybe that's the latent intention behind this.
Mr. Tara cannot call me up. Dada, move this matter for me here. He'll have to call me there, my lord.
No, but otherwise it's a serious issue raised, and you can't
understand.
just give an answer in one go.
My lord will not also, not even venture to that.
Meghalaya is of not ever much help. Because
I'll get that Bombay thing, my lord. Try to get some
on a
judgments also.
totally different context.
Tuesday, next.
My lord, may I just make a submission, my lord? Meghalaya case, in this principle is, if it cannot have been filed in Meghalaya, then the case petitioner could not have been transferred to Assam. That is the main principle.
If it
now,
can
my lord,
be filed, then
this is also the same thing. But when this case could not have been filed in the Guwahati High Court, when Tanagar permanent bench is functioning,
No,
then question of
Patil, you are
transferring
wrong.
the same thing
Yeah,
Also-
you are on the wrong track in that.
No, no, no.
Yeah, that's correct.
Principle will be, if it could have been filed in Arunachal Pradesh, could it have been transferred to Guwahati?
Yes.
And definitely this could have been filed in Arunachal Pradesh. So
Yes.
that's why I say Meghalaya.
Meghalaya may not be very
It's
much.
of no use almost.
If your lordship can
Definitely
have it
good.
next week, convenient to my lord, any day, I'll get those details, and if possible, I'll give it beforehand to my Mr. My lordship.
Sir, any day, it should be conveniently on Friday.
You want it on next Tuesday?
Tuesday, Wednesday,
But,
whenever it's convenient to you. lordship.
Next
this,
Tuesday you want it?
Friday.
No,
would
no,
be-
Tuesday will be
Any
15
Friday,
15 August.
Any Friday would be convenient for us because I have.
Friday
plans-
is also a holiday,
Yeah.
madam. This Friday is.
24th.
next Friday is a-
Don't put it on a Friday.
No, no.
Friday.
My lord, we'll
Put
have
it
it on a hearing day,
Put
my
it
lord.
on a Monday if you want. We don't mind.
Lordship. My lord, we'll then have it on 21st, my lord. If not, others inconvenient.
21st, let me check up.
Let it be on 24th, Thursday,
No problem. No problem. Subject to what, my lord?
Thursday, 24th.
Today, what do you do? Should we issue notice and ask you to file reply
Let
or?
it be
we
like this,
keep it
because
like
all
that?
the parties are there.
Let
But one
let
vital
it be
party
an
is not
admission
there,
hearing.
madam.
Let it,
The NHPC. Who is the main?
Why do you need the?
No, no, I'm just pointing out, my lord. NHPC may also have a say
Why?
if they want to have a say, my lord. Because they are the, I think, the,
See,
in the other writ petitions, they are the.
Now-
main-
now-
they may be.
Now
For
the-
them,
my lord,
how it matters, where the matters are
No,
held.
no, I'm not on that. my lord.
So
They
then
may
how
also
can-
have a view like the, same view like the, my lord, petitioners. I don't know.
No,
Or maybe like others, my lord.
for this proceeding, we don't file
Okay, fine,
NHPC.
I just
necessarily.
pointed out. I just-
For the,
Because I found
for
that
the,
the
for
whole
the-
issue is with regard to NHPC.
for the claims made against the NHPC in the
Mr.
original.
Nair
writ pet-
has a
Clear
concern
understood.
for NSPC.
But here is a case, the issue raised is the power of the Chief Justice to
Transfer.
get it transferred
No, I
unilaterally
don't
from
know,
there
my
to
lord,
there.
exactly what was the grounds.
So we are not required to hear NHPC.
Yeah,
NHPC will
absolutely,
take the
Milord,
matter
because-
wherever it is listed.
It is only,
They have councils everywhere, so there is no problem. My lord, we'll have it on whenever. 24.
sir, on 24.
24. Lordship.
So,
24
in
months.
other words, Mr. Nair, just think a little ahead.
I'll do that. no?
One, whether Chief Justice being the master of the roster, that principle will be applicable in that form itself in respect of the Itanagar bench. Whether Itanagar bench is one of the extended courts of the principal high court, or Itanagar bench is something a little beyond that. Here, Chief Justice, the master of law, whether it will be court 11 or court 6 or court 5, Chief Justice will decide. You don't have anything. But is the bench at Itanagar one of the extended form of court 5 and court 6 here? Or it is at a little variance?
Independent.
My lord, if I may indicate.
This is
subject-
number one. We
Yeah,
have to
correct.
look into it. If it is at a variance, whether the principle simply stated that the Chief Justice, the master of law, will be applicable ipso facto. If no, definitely it is yes. If yes, then what will happen?
How will it be done?
Next that will come is,
Take a look.
if the concept of master of the roster is not applicable simpliciter. Next eventuality will be under what circumstance this discretion can be exercised.
My lord would have the cause list of Arunachal Pradesh, just for my, just something struck me, my lord. My lord would see the top portion, my lord.
Authority, definitely.
Authority of the Honorable Chief
Definitely.
Justice, Guwahati High Court.
Definitely. Whether this Itanagar bench cause list is one of the another courtrooms of the Guwahati High Court, or it is at a variance. This is the question we are asking.
My lord, if I may just understood, my lord.
Definitely, Chief Justice is in charge of
But if I
Itanagar.
may-
We cannot say that the
He
Chief
is the
Justice
chief
is not in charge of that.
If I
So
may understand-
therefore, the cause list in Itanagar has to be published under the authority of the Chief Justice.
Well, if I've understood. my
But
lord,
that will that itself make it that
Oh.
it is another courtroom of Guwahati High Court?
Malad, just Malad, if I've understood, just to Malad, for my sake. Malad, Jodhpur and Jaipur, whether it can be deemed, I deem it that Jodhpur 1, 2, 3, Jaipur can be 4, 5, 6. Whether that concept can be brought in. When, my lord, it's not Jaipur and Jaipur, it's Itanagar and Guwahati.
This is what
Got
we
it.
are, this
I
is
got it.
what we are trying to
I got it.
understand.
I got it.
Because there must be some legal implication of this
24-2,
Act,
24-2.
State of Arunachal Pradesh Act 1986, and let us read 24-2. I have it slowly we're reading.
Lordship.
The president may by notified order provide for the establishment of a permanent bench or benches of the common high court. Mind you, permanent bench and benches of the common high court had been distinguished in that Arunachal Pradesh Act. At one or more places within the territories to which the jurisdiction of the high court extends. Jurisdiction of the high court is definitely there in Arunachal, no difficulty. Other than the principal seat of the high court, and for any matters connected therewith, provided that before issuing any order of under this, the president shall consult the chief justice of the common high court and the governor of the state in which the bench or benches is or are proposed to be established. 3, notwithstanding anything in subsection 1 or subsection 2, the judges and division courts of the common high court may also sit in such other place or places in the states of Assam, Nagaland, Meghalaya, Manipur, as the chief justice may, with the approval of the governor, appoint. 3 is nothing.
Nothing to
3,
1 and 2.
any judges can go and sit. 2, one says the principal seat of the common high court shall be at the same place where the principal seat of the high court of the Assam, Nagaland is located.
That's
Okay, this
got
is
it.
also not
That is Guwahati.
only 2.
That is got it.
President may by law provide for establishment of a permanent bench or benches of the common high court. What is the legal implication of the expression
Well,
permanent bench or
Benches.
benches of the common high court?
So, my lord, if it was.
So
not a
now, if we look at this
bench, 24.
order frame, this order may be called the Guwahati High Court establishment of a permanent bench at Itanagar.
349. 349.
249 page. Yeah.
349. Yes.
So the option of having benches of the common high court had been avoided, and the option of having a permanent bench is adopted.
My lord, there was a
So
bench
the
earlier.
legal
No,
implication.
there was a, if I may, my lord will know. There was a bench earlier. And then, my lord, from 2000, no, bench.
2012 August,
No,
2012 August, sir.
my lord,
2012 August,
2000.
12 August,
12 August.
12 August 2000, 2000.
2000, okay. 12,000.
Well, August 2000, what happened
The bench was set up there. my lord.
Set up here.
Permanent bench was set up.
prior to it?
Prior to it, my lord, it was.
There was no bench in
My lord,
Itanagar,
could have
my
been
lord.
there.
No,
was
no, no.
benches.
There was no bench.
No bench in
We all
Itanagar.
used to come to Guwahati
court.
only.
No court.
No court, man.
No court.
So this was the first time, my lord, 2000 years, because all those cases were being filed here.
So, but this one speaks of a permanent bench. Established a permanent bench at Itanagar.
Lordship.
So the expression
Benches.
permanent bench or benches of the common high court in 24(2), it gives 2 different meanings.
Lordship.
If it is benches of the common high court, maybe
It would be continuation of 19, 20, 21.
21. There the concept of chief justice being the master of the roster
Would have come
would
in.
have been squarely applicable.
Master of roster still there, but whether master of roster
Simplicity.
or master of roster Arunachal, master of roster Assam.
So these two,
Yes, yes.
whether the chief justice is exercising jurisdiction of the master roster in one jurisdiction
Or two jurisdictions.
or two separate
I got it.
jurisdictions.
I got it.
If the chief judge is
Two
exercising
different-
in
it would be
two
difficult.
separate jurisdictions,
Then it would be different.
just because the authority is one authority,
It can.
whether it can be done or not.
Governor of Nagaland, governor of Assam, same man. But he cannot, my lord, do it.
This is what we are trying to ask you.
Lordship, I'll try.
Yes, my lord.
But in this
Yeah, my lord,
context, my lord, maybe that proviso would, my lord, give some, I'll try to do that. I'll try.
My lord, in that context,
My lord,
I
I have
have
it on 24.
I have one proposition in there.
Just,
Yes, Mr. Tara?
my lord, can
Yeah,
I
my
just?
lord, I have one proposition
matter is going
on
on.
this. What happens is, there is always a quarrel between the cabinet and the governor. All the decisions are taken in the name of governor in exercise of its executive power under Article 152. The
Or
cabinet,
150.
yeah, the cabinet takes a decision under 166, and under 166 clause sub-article 3, the person authorized to exercise, issue the order, authenticate the order in a particular manner, my lord. So that is the concept here, my lord. So the governor says, you take decision in my name, and file never comes to for my perusal and considerations, my lord. So this could be one of the situations, my lord.
So what do we do? Mr. Patil, we are not issuing notice.
No, my lord, I think no need to issue notice. Let us,
Because it's absolutely.
on the last date, on the next date, we will try to.
No factual, it has to be controverted in any manner.
Correct,
It's
correct,
only independent.
Let it be
So understand that the hearing has started.
yes, my lord.
Mr. Das, you also understand hearing has started because possibly there's no requirement of any affidavit.
No,
And
No,
if
no,
you-
my lord.
And if
Absolutely.
there is requirement, you file your affidavit if you want.
it's absolutely a point of law that is.
And if you want to file, you file it before the next date.
Lordship.
Correct, correct. That's fine.
Although the matter has been listed for the first time for motion, but the issues raised appears to be a decision required on purely questions of law, without there being any difference of views between the parties on the factual situation. In the circumstance, all the parties involved, that is the writ petitioner, the authorities under the Guwahati High Court, as well as the Arunachal Bar.
Guwahati High Court, Itanagar Permanent Bench
Guwahati High
Bar
Court.
Association.
The formal name is Guwahati High Court.
Itanagar Permanent Bench Bar Association.
Guwahati High Court, Itanagar
Itanagar Permanent Bench Bar
Permanent
Association.
Bench, Bar Association
Yes, my lord.
are in agreement that the hearing of the matter can be proceeded, and accordingly the hearing has started. Arguments have been advanced by Mr. T. Pertin, learned counsel for the petitioner, Mr. T. P. Tara, learned counsel for the Itanagar
R3.
Permanent Bench Bar Association, as well as Mr. U.K. Nair, learned senior counsel, assisted by Mr. H.K. Das for the authorities under the Guwahati High Court. List again on 24/8/2023 as agreed upon. In the meantime, if either of the parties intends to file any further pleading, they will be at liberty to do so. With,
My lord, virtual option may
Copy.
be kept open.
sorry,
Virtual option may be kept open.
you don't like Guwahati?
Okay, my lord.
We would love to, but
Okay.
virtual is better.
Okay.
No problem, my lord. We shall come down. No problem.
No, doesn't matter. We are not asking that. On that given day, you give a requisition, we'll give you a virtual if you want.
Grateful.
The day the matter is listed, the day prior, you give a requisition, we'll put up the virtual.
Physical argument is always better than the virtual argument. my lord. Grateful.
Mr. Patil? Thank you.
Well, it's 24. 24/8.
24.
Yes. Grateful. my lord.
Thank you.
Thank you.
Deep.
Hmm.
On the right.
Item 7 to 38 per admission.
Obliged, my lord.
Oh, Mr. Patel, Mr. Thank you.
Lordship, I seek some accommodation in the matter. The Lordship, senior counsel is not available due to some.
Not available.
No, no, no.
You want to start today, your reply?
No.
Or you want to wait for Dr. Sarma?
Senior counsel, that may be concluded.
You stated that Mr. Dr. Ashok Saraf, and saying counsel is having some inconvenience today, adjourn. To be listed on.
22nd.
22nd.
22nd. Highly obliged.
Don't take it on 22nd.
Your Lord-
24th need to go. On 24th again, the rematter will come up.
obliged.
Timing item 39.
Or 22nd will be single bench.
No, no.
39.
Yes, ma'am. And last order, my lord, 8-6, my lord.
Yes, who appears for Deputy Commissioner?
You
Nagaon?
does.
No, I already got it. Or to them. But is it? The government or tax matter was having.
Take it as-
Namaste. You were there for the Deputy Commissioner Nagaon?
Earlier, I remember, no, in 1967.
You read this order.
Yes. Today, earlier, Sir Das was here in this case. Another advocate was there. I have seen that. I will produce any other day.
Your name is Sharma.
T-shirt.
P. Sharma. Mr. P. Sharma, and the advocate for the Deputy Commissioner Nagaon states that the required information as per the order of 15/5/2023 would be produced on the next reasonable date. They allowed list on so and so.
Timing item 40.
Item 40, yes.
May I please, Lordship?
Please,
Lordship, English senior counsel is out of station, kindly pass over. People obliged.
2017 matter, you pay cost. It stated that Mr. Lawrence Senior Counsel representation is not available. And therefore, adjournment is consumer matter 2017, a cost of 2,000 be paid. Next item.
Please.
Item 41.
Because here the petitioner you come thus.
But where is your respondents? Are they present or not? You were there? Item 41.
Shivani Road arrest.
I think Lordship it was. I think Lordship it was adjourned.
Actually, it was adjourned. So earlier order will remain.
Five.
Yes, 45.
My lord, this is a.
So
My-
your claim taken into custody on 4/6/2018. They substantiate through some material that he was taken into custody on 6/6/2018. Now you substantiate that you were taken on 4/6.
My lord, that is the, my lord, difficulty is that, my lord, when the police, my lord, went to my house, my lord, they have seized the, my lord, TMT bars, along with, my lord, bring me to the police station. My lord,
From where did the seizure take place?
my lord, the seizure take place from, my lord,
Where is the seizure list?
seizure list they have not furnished, my lord. It is, they have said that it is submitted along with the charge sheet, my lord.
Along with?
Along with the charge sheet.
Hmm.
It is reflected in the charge sheet also, my lord. My lord, what has happened if my lord allows me?
From
My lord.
from which place was the seizure made?
My lord, seizure was made from my house, my lord. My
House.
my residential house, wherein, my lord, I purchased those TMT bars, put it there for the purpose of construction of my dwelling house, my lord. My lord, I am a professional driver as well as small cultivator also, my lord. And by following.
You are cultivator and driver
No, my lord, some.
and undertaking construction of a house.
Small dwelling house. my lord.
For the small dwelling house, you brought some
TMT bars.
iron rods.
Iron rod.
How much quantity of iron
My
rod?
lord, it is in the, my lord, 10 AM TMT rod, my lord, 270 kg, my lord.
270
kg.
kg.
14,890 rupees, my lord. Cost. Just, my lord, just a purchase from a small hardware, my lord, that.
Where is your receipt of?
My lord, at
making
page
that
15, my lord,
Page?
page 15, my lord.
15.
This is, my lord, Mukuta Enterprise. My lord, may I kindly note the date, my lord, is of 4/6/2018 at top, my lord.
Do one thing.
Lordship.
Seize the receipt book of this Mukuta Enterprise of that period.
Lordship.
Really?
Yes,
Get it and bring it to us.
Lordship.
My lord, another thing. My lord, another thing.
Seize
my lord.
the counterfoil
Yes,
of these
Lordship.
bills
Yes, Lordship.
of this Mukuta Enterprise.
Yes, Lordship.
My lord.
Ah,
And tax, this is also not there, there should be a certain, because
No,
this is a simple
first,
plain receipt. Lordship.
first let us
That's
know.
like a challan only.
এখনো counter file করছে না? মুকুটা enter করেছে। এটার উপর কি আছে?
Milord, may I try another thing, Milord? Milord, when I was illegally taken into custody, Milord, I made a complaint before the Director General of Police, Milord, the wife of this victim, Milord. And that has been acknowledged by the DGP office, Milord, at page
Which
20
page?
page 21, Milord. Police headquarters seal is there, Milord, at page 21, bottom, Milord, at left-hand side bottom, there is a seal and receipt of this police headquarters, wherein I have.
No, this was made on 7/6.
7/6,
7/6, you were already taken to
Milord, it is
custody.
there stand, Milord, in presence of the Gaonbura, Milord. I was released only on 8/6, Milord. And-
So therefore your wife makes a application on 7/6.
Milord, after this application, Milord, they have come into, Milord, acted. This case was registered, Milord, on 8/6, they have released me.
Whatever it is, they are admitting that they took into custody on 6/6.
6/6.
They are admitting it.
My lord, my lord.
When case is registered is a different aspect,
lord.
but they, as per their admission, they took into custody on 6/6.
6/6.
So on 6/6, definitely the man was taken to custody.
My lord, they can.
So on 7/6, the wife can always write. And wife can always put in any date. Wife can write 6, wife can write 4, wife can also write, you're taken on 3rd. That will not establish that you were taken on 4th. One relevant material, you say that the goods were seized from your residence on
4/6, Milord.
4/6.
My lord.
But
Around what time?
Lord, at 9 AM, I was taken into custody along with.
Just
this-
a minute.
9 AM.
On 9 AM, you were taken into custody
My lord.
of 4/6.
4/6, Milord.
And before that, the rods were seized from your house.
No, no, Milord. After the arrest, Milord, this subsequently seizure has been made, Milord.
What time the rods were seized?
Milord, exactly that time, Milord, I have not mentioned.
Please read it. What,
He says,
forget about that. What time was the rod seized?
as per petitioner, on 9
As per
AM,
you, as per the police, what time the rod was seized? Because as per his claim, he was taken into custody at 9 AM on 4/6.
Lordship, his,
And initially he said the rod was seized and was taken into custody. Now
his
Mr. Bhuya,
box is from his house.
now Mr. Bhuya had changed his statement.
Yes,
He said, I was
Lordship.
taken into custody first and then
Yes,
the rod was
Lordship.
seized.
Milord, they.
Just a minute, Mr.
My
Bhuya.
lord, my lord, my lord.
We can put the recording
Yes,
on.
yes, I can.
We can,
No, I have made that statement.
so now what time the rod was seized?
as per my affidavit, it says, on 12 o'clock, 5, 6, 18 and 12.
We don't want those 12 stories. On 4, at what time the rod was seized?
Lordship, as per the report that has been submitted by the officer in charge, Lordship, on 6/6/2018 at 5
5 AM
AM.
it was 6, we are with that.
Patrolling
now-
party of Hajj.
According to you, it was seized, at what time it was seized?
Milord, along with me, Milord, the.
Along with you, at 9 AM it was
Seizure
seized.
made, my lord.
Now,
But that seizure list they have not given to me.
need not give. It is your own admission, rods and a person taken to custody, rods seized at 9 AM or 4/6.
My lord,
Very well, I accept that statement.
my lord,
Now, if you look at the bill of Mukuta
my
Enterprise,
lord. It is of 4/6, Milord.
4/6.
My lord,
So at 9 AM.
my lord.
So what time did you purchase the rods?
Lord, on the.
At 6
that-
AM,
No, Milord. So early it cannot be, Milord.
cannot be.
Cannot be.
So definitely this is a fabricated bill
No, that can be verified, Milord.
or a bill obtained after seizure of the rods.
That, Milord, I can't. submit.
By your own statement, Mr.
My-
We are not asking them, we are
My-
going by your own statement, your own material. You say, I was taken into custody, rods were seized at 9 AM on 4/6.
My lord.
And that, these are your rods. To show it, you rely on that
Receipt, Milord.
bill. Bill is also dated 4/6.
This my lord can verify, Milord. If something is.
Not
wrongly-
verify, it is you who will have to
No,
explain
no,
now.
my lord has called for the record.
Hmm.
Statement to come negative. Statement. One is construction of dwelling house, transported the same house, suddenly on the same day, at around. This is statement to something double, this is 8 years.
Bhuyan and counsel for the petitioner makes a statement that the petitioner was taken into custody by the police at 9 a.m. on 4/6/2018. And while he was taken into custody, the police had also seized the offending rods from his premises. According to Mr. Bhuyan, the petitioner is a driver as well as a small-time cultivator, and he had purchased the rods for the purpose of construction of his house. To substantiate that the rods were purchased by the petitioner, reliance is placed on a bill at page 15 to the writ petition, which is a bill issued by Mukta Enterprise. Of Amingao, Kamrup district, bearing bill number 218 dated 4/6/2018. The residence of the petitioner is located at Hazo. At Hazo. And his allegation is that he was taken into custody by police from his residence on 4/6, and the rods were also seized at the same time at 9 p.m. 4/6 from his residence. Petitioner to explain the inconsistency that if the rods were purchased by him from Mukuta Enterprise for the purpose of construction of his house, rods were seized at 9 a.m. from his residence at house. Under what circumstance a bill was issued by Mukuta Enterprise on 4/6/2018 for purchase of the rods in a situation where Mukuta Enterprises is located at Amingao, which is a place apparently different from that of Hazo. List.
Make an, I'll file an
So
additional.
your stand is inconsistent with what we are.
No, my lord, I
You
will not,
explained it.
I will not defend the person, my lord. if
No,
it's
no,
not
you
my-
explained it.
My lord, even then, my lord. if
You
it's-
can say Mukuta Enterprises shop which opens at 5 AM in the morning. I went there, purchased the
No, no,
rod, came
that is
back.
not- That is not
Rod
possible.
was arrived at my house at 7 AM.
I will not defend my client, my lord, if something is not bona fide, my lord. But my lord.
And in their own stand lordship, they have stated not at home lordship in para 3. And now they are telling this is
No,
there.
no, paragraph.
And till date lordship, if they have the
Madam
valid.
Bhattacharjee, we are yet to look into all those.
Yes,
aspects.
lordship.
We are only going by the statement of the petitioner.
My lord.
Lordship will be fixing the matter.
Next week, by Friday? Can you do it this Friday?
My lord, I will try. my lord.
On Monday.
I think, my lord, I will be out of station, my lord. After 16th or 17th.
A scan copy of the CD of Hazo Police Station case number be also produced on the record.
Lordship.
CD must have
Yes.
been deposited in the court. Get a scan copy.
Lordship.
17th.
Or do you have the duplicate copy?
Duplicate lordship, I have to ask
I
from
think-
the SP lordship.
4 copies of the CD is
Yes,
prepared at the time of submission of charge sheet.
Yes, lordship.
One with the OC, one in the court, one with the SP of the district, and the fourth one inspector, circle inspector.
Okay, lordship.
So somebody must be having a CD.
Lordship, I shall.
We will.